Everybody ready? Good morning, everybody. Welcome to Mine Land Reclamation Board meeting for July. It's Wednesday, July 16th, 2025. My name is Quentin Redmond, and I'll be the chair for this meeting. I think the first thing is roll call. Is that what we need to do? Director Mao? Present. Ms. Nelson?
Present.
Ms. Wareham?
Present.
Mr. Baker? Present. Mr. Oren?
Present.
Online. Ms. Stiegelmeyer?
Present.
Very good. Everybody. All right. Second thing is approval of the June minutes. Has everybody had a chance to read them? Everybody have any comments, changes?
Motion to approve the minutes.
Very good.
I'll second it.
All right. Everybody in favor? Aye. Anybody against? Okay. Minutes are approved. Let's see. All right. Number 2, approval of continuances and withdrawals. There are none, so we move on. Number 3, Executive Director's Office and Division Director reports. Mr. Mao.
Thank you, Mr. Chair. Good morning, board members, Director Cunningham, Tim Mock, Deputy Director for the Department of Natural Resources. A couple updates here. Can't remember the last time we met, but I was out of town. That's what happened all that. So anyway, since then, we actually had our Deputy Policy Director, Kelly Romero Heaney, resign. She got a fantastic offer from the city of Steamboat Springs, where she resides, to be the deputy city manager up there. So she had to take that. In her absence, we have appointed Aaron Ray as our policy director. Aaron most recently has been serving as our assistant director for energy innovation, and we will also be working to backfill his position in the coming weeks here. I think, as I mentioned before, we continue to work through our legislative and budget proposals for the coming ledge session and next fiscal year. It's a multi-step process. We just began submitting our ledge proposals to the governor's office in the last, actually as of yesterday. We'll continue to work through those. Nothing's final until the governor makes his approvals and comes out and releases his budget and legislative agenda, and that's usually around November. On the federal side, beginning this month, several federal agencies, you may have heard of this, including DOI, USDA, USACE, and FERC announced their revised NEPA implementing procedures, and it was an interim final rule. Policies focus on expanding the use of categorical exclusions, setting deadlines and page limits for the NEPA documents. However, there is little to no guidance on how agencies will work with cooperating agency partners such as the state of Colorado, and we are currently working to evaluate the proposed rules and determining if we need to submit some comments. State Land Board met last week in Fort Collins, or 2 weeks ago in Fort Collins. This was the first meeting which our new State Land Board Executive Director, Nicole Rose Marino, has served, as well as 2 new commissioners, Jim Pribble and Mark Harvey. The board and staff are coordinating with DNR on the implementation of 1332. If you remember this directive, State Land Board, to conduct a 24-person working group to identify new opportunities to advance conservation and recreation on state land board lands. The working group members will be appointed by September 5th. And we've got an RFP out that was launched on June 30th, looking for a project facilitator, manager, and so hope to have somebody on board really soon. We've got some tight deadlines on that project. On the energy side, ECMC continues its response to the Bishop Well control incident. We did at the end of June issue a notice of alleged violation to Noble Energy, a subsidy of Chevron. And that identifies potential violation of 6 ECMC rules and is beginning the enforcement process. On the water side, you also might have read recently last week, we announced, or Parks and Wildlife announced, that they have discovered a potential source for the mussel veligers that we've been finding in the Colorado. They've tracked it back to a private lake that has full-blown zebra mussels infestation. And so we're now working on figuring out how we're going to resolve that situation and contain them, as well as continuing to make sure that we are not overlooking some other potential sources for where those veligers are coming from. So far, we still only remain to find some veligers in the Colorado, not full adult zebra mussels. And then on the tribal engagement side, GOCO recently approved a $50,000 grant for CPW to conduct statewide community engagement outreach on state park matters with the Greater American Indian and Indigenous communities throughout Colorado. The outreach will be a form of listening sessions held throughout the state. The specific grant-related work will likely conclude in 1 year, and Parks and Wildlife, through DNR support, is currently working again to hire an Indigenous consultant to help support the development and implementation of those listening sessions. And that concludes my updates.
Thank you, Director Ma. Mr. Cunningham.
Good morning, Mr. Chair, members of the board. Michael Cunningham with the Division Directors Report. I'll start with at the end of last month, the Inactive Mines Reclamation Program conducted a 2-day Society of Economic Geologists summer course organized by the Western Alliance for Reclamation Management. The course aims to bring academic studies in line with industry expectations, providing field course participants with essential skills for careers in mining and reclamation. The curriculum covered topics such as mining history and activities at abandoned and operating mines, including waste management. We also covered techniques for assessing soil and water quality around mine sites, evaluating water quality tolerance for invertebrates, and conducting vegetation field work through this course. So it's a great opportunity. Kudos to the Inactive Mines Reclamation Program. We're always looking for ways that we can interface with academia and help to educate the next round of reclamation professionals. Moving on, yesterday, I, along with the Inactive Mines Program Director, Jeff Graves, attended the annual Symposium of Mining and Metallurgical Society of America in Leadville. This was put on in collaboration with Trout Unlimited. I'll also note we had the pleasure of running into board member Nelson at this meeting. The symposium marks the 7th in a series of public forums organized by Mining and Metallurgical Society and its expanding network of partners. The forum aims to unite stakeholders committed to enhancing landscapes affected by abandoned mine lands. The agenda primarily focused on current legislative and administrative initiatives related to the Good Samaritan program. And so it was a really good opportunity to get together with some of our Western states and hear some of the projects that they're contemplating for proposal on the new project. Colorado has identified several projects as well. We've got about 4 that we're thinking of. Our timeline would be to submit that application prior to October 1st, which is when EPA has signaled they're going to start reviewing these applications. Our next step will be to sit down and have a meeting with the EPA to brainstorm and get some feedback on these proposed projects. But when we get further down the line and we've either proposed a project or, fingers crossed, we get selected for a project in Colorado, we'd be more than happy to give the board the presentation on those projects. So I'll keep you posted on that. Next up, the last week of this month, we will be holding the 2025 Colorado Regional Mine Rescue Contest. This takes place every year. Our Mine Safety Training Group is a sponsor of the contest and assists in organizing the event along with staff from MSHA. These mine rescue contests are designed to sharpen the skills and test the knowledge of team members who would be called on to respond to a mine emergency. The contest requires team members to solve hypothetical problems while being timed and observed by judges according to complex rules. So this is incredibly important training that takes place and really gives our miners an opportunity to test their skills out in these mock situations. So we're looking forward to that. Next, I have a personnel announcement. I am saddened to say in part that one of our environmental protection specialists will be retiring from the division. Robin Riley has announced she'll be leaving the DRMS family at the end of August. Robin has been with the division for 10 years, working in our active mines program. Her background is in surface water, hydrology, and GIS. So we're going to miss her greatly, but at the same time, we're happy for her moving on to the next chapter of her life and wrapping up an amazing career. Last but not least, I want to announce to the board, I'd be remiss if I didn't let the board know that our board administrator has a birthday tomorrow. So happy birthday, Tammy. And with that, that concludes the director's report. Happy to answer any questions from the board.
Do we have cake today then?
Yeah, I was gonna say, wow, it's a party. We didn't even know it was coming. Happy birthday, Tammy.
Just a reflection from yesterday is in watching all the states prepare for the Good Sam pilot program that's coming up is we were well represented with Colorado. They stood up and it was
Good.
Nothing that I did, but sure made me proud. So good job. Thank you to you folks. Mr. Graves.
Great. Any other questions for that or anything? Okay, all right. Number 4, consent agenda. There is none. So, all right, on to the big piece here. So we do that first or what? How do you want to?
Yeah, so we've got one outstanding motion that maybe it makes sense for us to deal with and then move to the pre-hearing order.
How do we want to?
Yeah, I can just, so this is Chuck Coyman, I'm counsel for the board. I can just kind of tee this up for the board. This was a late motion that was filed by objector Kim Coleman on Monday, seeking to add another Bill Caldwell, who is a party and an objector, as a witness. And so just for everyone's edification, once you have party status, you have party status and you can speak at the hearing. There's not really a need to designate someone who's a party as a witness. If they're going to talk, they can just be allowed to talk because they're a party. And kind of given that, it might be, I mean, the board could ask Ms. Coleman to just withdraw the motion as unnecessary, and that would save.
I mean, Bill's already able to speak because he's a party.
Correct.
So the motion is really not needed, is what you're saying.
Correct.
Is that probably the easiest way is to?
Yeah, if Ms. Coleman's willing to withdraw the motion as
She's online. Is she online? Yes.
I am, and that would be absolutely fine. I figured as much since he was a party, he could speak. We just wanted to make sure that he was included to describe some of the exhibits.
Okay. So is there a formal, how do you do that? Formally retract the motion?
maybe Ms. Coleman can do that now if she wants.
Sure, I'll withdraw my motion.
Very good. All right, that's in the minutes, right?
Yeah.
Okay. All right. What's next? Do we have to get through these, or do we actually?
Oh, don't worry about that. That's, I mean, so there was a separate motion filed by the applicant to have a couple witnesses appear remotely. Again, that kind of fell into the category of like, this is a hybrid hearing. That was probably not a necessary motion to file, but because it was filed, the board chair ruled on that under the policy that allows the board chair to dispense with motions in between hearings, and just kind of belt suspenders. So everyone's aware. Two witnesses, or I guess two folks for the objector, will appear and testify remotely
For the applicant.
for the applicant.
For the applicant.
Yeah.
All right.
But that's taken care of, just so everybody in the board, on the board saw that in the packet.
So it's a hybrid meeting, so it's not necessary, but I signed it anyway.
Yeah, it's one of those things. Our rules around hearings are, we haven't amended. They still kind of cover like telephonic testimony, which back in the day was a real ordeal to set up. Since COVID, it's not a problem anymore. All of our meetings are hybrid. We have parties appearing over Zoom. And so it's just a little, it might be something that we can adjust those rules going forward to kind of address the current reality. But
So, but everybody's available online and in person.
Yes.
Yes. All right. Two more things here. What in order.
And Travis Marshall was the pre-hearing officer for this application, and he can tee up the pre-hearing order for the board.
Okay, can everybody hear me?
Yes.
All right, good morning. This is a formal hearing for the Farmers Reservoir and Irrigation Company Farmers Sand 112C permit application. Division file number M 2024-057. As Chuck said, I'm Travis Marshall, Senior Environmental Protection Specialist for the division. I represented the Land Reclamation Board during the pre-hearing conference. At the pre-hearing conference, a total of 6 jurisdictional issues were identified, and none of those issues were resolved during the pre-hearing conference. During the pre-hearing conference, the allowed timing allotments were agreed upon by all parties and are presented in the draft pre-hearing order. And the draft pre-hearing order is included in the board packet. The board shall consider this draft pre-hearing order for adoption. The board, in its discretion, will hear any objections to the proposed pre-hearing order at this time and make any necessary amendments prior to adopting the pre-hearing order. And this concludes my presentation.
So we need a motion to approve this in the vote. Is that what we're doing?
Yeah.
May I
Just ask.
speak real quick?
Sure.
Hi, Philip Lopez. I'm the attorney representing the applicant Farmers Reservoir and Irrigation Company. At the pre-hearing conference, I had asked for a short or a small amendment to the pre-hearing order that I be allowed 60 minutes for my initial presentation and reduced my rebuttal time to 10 minutes. And I was told that I would have to request that from the board before the hearing. So I would prefer to have more time up front in order to put on my prima facie burden, as opposed to having 30 minutes for rebuttal.
That's something we just vote on to amend this.
Yeah, so
So
do that. It's the same.
The same amount of time.
Same total time.
Yeah.
Ruben.
So it's from 40 to 60 and from 30 to 10.
Yeah.
D and item.
Right. So. 60 here. 160 here, and 10 at the end.
Correct.
Yeah. So, all right, but any objections, any discussion? Do I have a motion to approve that with the change?
And sorry to interrupt you, but I had one more objection that I had made at the pre-hearing conference that I would like to renew just for the record. There was on section 4 of issues, issue 6 regarding proper notification of the permit application. That issue was raised by an individual who did not qualify for party status. And so I had made the objection at the pre-hearing conference that since that person did not qualify as for party status and was the only person who raised the issue, that other parties should not be able to raise that issue. That was at the pre-hearing conference denied, but I just wanted to make sure that I had it in the record that I was again requesting that deletion of that issue.
Number 6.
Or if this board would be inclined to agree with that deletion.
I mean,
Excuse me, can I question that? I couldn't hear what he said, because I'm opposite of him.
sure.
I didn't ask what he's excluding, or I couldn't hear what he was excluding.
Sorry.
Go ahead.
What was your name? Are you?
I'm Bill Caldwell, I'm here as the neighborhood witness.
Yeah, so this is Chuck Coyne, I'm appearing for the board. He was asking to strike, I guess, issue 6, which is concerns regarding proper notification of the permit application and listing of BB Draw Farms Authority from within Exhibit B per Rule 6.4.16, parent 1. And did you hear that?
I heard that.
So
Both speakers here today for the opposition have comments on that particular document. And we were told, somehow we were told that we could speak on any one item of those 6. And I'm prepared to make a comment against that particular item. If you exclude it for one person that can't be there, then you're excluding me. I should be able to speak about that.
How does that work if a party that doesn't have status? I mean, does that mean another party can't? But they didn't say it at the hearing.
Mr. Chair, if I might,
Yes.
way I kind of see it, I would note the objection raised by the applicant. I think we tend as a board to be more inclusive, and permissive of public discussion and comment, and so I'm fine upholding that portion of the hearing order.
And the fact that it was contained in the pre-heard order.
in the
I
order.
think we should keep it in.
And I would say also, just given that it's not a terribly lengthy amount of time given for the presentations, with 6 items to go through.
Right.
It's at their discretion of how they might choose to use that time, and also reflecting Director Mock's.
Understood. I just
All
want to
right,
make sure
so
it's in the
it's noted.
record in case it gets appealed.
Thank you.
Right,
Yeah.
so it's noted.
Excuse me, yeah, I can't hear. What did we just say there? Can I speak about that number 6 item?
So, yes, sir. In the fashion of being more inclusive, his comment has been noted, but you'll be able to speak about it.
Thank you.
All right. So now we need to get a motion.
Please
speak up
Yeah.
just a little bit for me,
Um,
because I can't hear from here, so I can't catch them on my recorder.
and do you want us to state our names when we're speaking?
Yes.
So we just catch it in the note.
All right.
Nell Wareham, I move that we adopt the draft pre-hearing order, noting the changes, requested by the applicant, on D, that they should have 60 minutes for their presentation, and H, 10 minutes for their rebuttal.
I second that, Mr. Baker. Very good. All right, all approve? Aye.
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 Any against? Hearing none, the draft pre-hearing order passes. All right. So now we're actually on the hearing. Yeah, whatever. All right. All right, so now we're actually on to the hearing number 5. We need to get everybody that's involved to raise their right hand and swear to tell the truth. I swear to tell the truth. All right. So who's first here? Chris Gerard. Yep, great. All right, first we'll hear from staff, Chris Gerard. Thank you.
PowerPoint slides, the agenda worksheet, and the division rationale.
So I have to read all this in 10 minutes?
Yes,
So are these, do these go out to each of the individual?
yes.
Oh, I guess, there you go. Oh, thank you. All right, thank you.
You got
Oh,
You got one?
I have.
Yeah.
Oh, I see. So. oh. I need one of those.
Need one?
Then each set of these two.
You guys have a presentation from the group folders, so.
What? The difference.
Yes.
So,
I sent you these yesterday. Just in case you.
so just make sure everybody has this, we need construction materials application, staff presentation form. Letter dated June 13th, PowerPoint slides, everybody has a copy of that? Very good. Take her away.
All right. Well, good morning, members of the board. My name is Chris Girardi. I'm an environmental protection specialist for the division. I was the primary reviewer of the farmer sand application submitted by Farmers Reservoir and Irrigation Company, also known as FRICO. This is a construction materials 112C permit application. And in this portion of the presentation, I'll be explaining the basics regarding the mining and reclamation plan, as well as the chronology of the application. Okay. So again, the applicant is FRICO, the Farmers Reservoir and Irrigation Company. The proposed permit area is 2,497 acres. The proposed affected area is 1,080 acres. The primary commodity is sand, and the surface and subsurface owners are FRICO and REI LLC. The proposed mine is located within Weld County, shown over here. It's approximately 9 miles east of Platteville and 11 miles south of Greeley. And as you can see, there's several different surface water bodies that kind of feed into and feed out of Milton Reservoir. Some more general information. The applicant proposes to use a dredge operation to mine sediments located at the bottom of Milton Reservoir. The processing methods include dewatering using a vortex cyclone and a series of settling ponds. The proposed post-mining land use is developed water resources. So this figure here shows the proposed permit boundary and the affected lands. The black dashed line indicates the proposed permit boundary, and this blue shaded region here indicates the affected land boundaries. Also worth noting, this red line running over here, this is the Evans number 2 ditch. I just wanted to highlight that as that'll be pertinent in later slides, as well as this is Lake Christina right here, located outside of the permit boundary. So the existing site arrangement out here, so this is Milton Reservoir, and this is where they have a pontoon boat where the dredge is fixed on. This purple line indicates a large HDPE pipe that essentially takes that material that's dredged over to the shoreline. Over here, this is where the cyclone is located that does the processing. Right here, this is the stockpile, or this is the N1 stockpile. Over here, again, is Milton, there's Lake Christina. And then over here, these are settling ponds in the northern side of the proposed permit area. And then the existing arrangement on the south side, again, this is Milton Reservoir. Over here, this is the designated mine entrance location. Over here, this is the west stockpile. This is the stockpile 1. And over here, it's not kind of showed in this figure, but this is where where they have discussed a potential sand plant location. So the proposed mining plan, again, they're dredging material from the bottom of Milton Reservoir. They'll be processing using a series of settling ponds and a cyclone. There's no acidic or toxic materials that are used at any point during any of the processes. The material is eventually stockpiled and then would be sold off-site for commercial use. They also have they have proposed a series of earthen dikes and drainage swales to be installed around the stockpiles in order for stormwater management purposes. The proposed operation would be operational for 20 years. And then again, kind of mentioned earlier, over right here on the south side, this little rectangle indicates kind of the approximate location of where they would potentially install a sand processing plant that would, again, in the future, as those plans are not finalized, and if they were to do that, they would they've committed to submitting a technical revision to the mining plan to be approved by the DRMS prior to the installation. These two pictures here show picture on the left-hand side. This is the pontoon boat that contains the dredge. Essentially, a dredge, it's essentially a vacuum that just sucks up sediment that's located at the bottom of the reservoir. And then that sediment is sucked up as like a slurry. You have sediment and mixed with water, it's pretty saturated. And then that's transported via a large pipe onto the shoreline, where this is the cyclone apparatus, where that slurry mixture is dewatered using just kind of density differences, just to try to separate the sand from the water. The proposed reclamation plan, again, post-mining land use of developed water resources. All the sand stockpiles would be graded to a 3-to-1 horizontal to vertical configuration for the slopes or less. After final grading, the topsoil will be replaced on the affected lands, and then those lands would be revegetated using a seed mix of predominantly native grasses that are designed to establish a diverse cover and reduce wind water erosion. This is the seed mix. It's only foxtail millet is not a native species, but it's very helpful for establishing prevention for erosion. The proposed reclamation plan on the north side. So figure on the left-hand side, these are large stockpiles. This is the N1 stockpile, N2, N3, and N4. Again, those slopes will be graded to no greater than 3-to-1, so 3-to-1 or less, and then they'll be graded and then seeded. And then over here, these are the settling ponds. They currently only have these ones over here, but the mining plan has them installing more settling ponds in the future. And again, those settling ponds will be final grade and then seeded and vegetated. And then the proposed reclamation plan on the south side of the reservoir, and then this is the west stockpile 1, and the future sand plant location. Stockpile is again graded to no greater than 3-to-1 configuration for the side slopes, and then seeded, and the future sand plant just graded and seeded. The division determined that the bond amount to be held by the division to complete reclamation based on the reclamation liability for the site is $6,604,659. The applicant would submit this as a financial warranty if the application is approved. Going over the permit application chronology. So on July 30th of 2024, the DRMS received an inquiry from Weld County regarding FRICO that they were dredging and selling sand off-site. The division responded on August 8th and conducted an inspection of that area. The division on August 19th issued an inspection report and cited corrective actions to FRICO. On November 12th of 2024, the application was received. On December 16th, the application was deemed complete and filed for review. In February 4th of 2025, the division issued our preliminary adequacy review letter. And then on March 7th of 2025, the public comment period got closed. The division conducted our pre-operational inspection on March 24th. And then on April 10th, FRICO responded to the division's initial adequacy review. On April 17th, DRMS sent out an informal guide regarding DRMS and a guide to public participation in a 112C permit application to all of the objectors. On May 7th, DRMS sent a second adequacy review letter to which FRECO responded on May 9th. And then on May 21st, DRMS sent a third adequacy review letter. On June 4th, FRECO responded to that letter. And then on July 11th of this year, a notice of the pre-hearing conference and the formal board hearing was sent to the objectors and FRECO. And subsequently on June 13th, the division issued our rationale for recommendation for approval of the application. On June 26th, DRMS sent that rationale to document to the objectors. On July 2nd, we held the pre-hearing conference, and then today is the board hearing. Questions?
Just a question about a matter of process. Does this also go through local permitting process with the county?
Yes, my understanding, they are going to be required to get a special use permit through the county.
That hasn't happened yet, though. I mean, is that in process?
The applicant might be able to speak more to where they're at in that process. I'm not quite sure where they filed that or not.
Yes, that is underway and any day push that.
All right. So, you're the applicant first. President. Oh.
So
yeah,
this is a new permit.
Yes.
The site has been in operation doing these sorts of things for a period of time,
Since 2021.
21,
Without a
without a
permit?
permit.
Without a permit.
And yeah, can we back up a bit? Like, what is the state of this reservoir pre-July 2024? Is there public access to this reservoir? If you're gonna address that in your applicant, then I don't wanna, should I wait?
We'll address all of
I'm
those,
needing.
of course. Yeah.
I read 1,152 pages, looking at the thing, I still need more contextual, like, I don't
Yeah.
understand.
We'll give you the background and the
Thank
picture
you.
as to why we're here.
Okay, that'd be helpful.
Yeah, I don't know. Big
This is a
picture, it
little
was an
bit of-
existing reservoir that's been around for like 100 years and they're cleaning out the set.
It's an irrigation reservoir.
It's irrigation.
It's owned by FRECO.
Yes.
That's owned by what?
FRECO.
Yeah,
Farmers Reservoir.
I'm gonna listen to the applicant's presentation before.
And we'll address some of this as well in our next set of presentation.
So do you have more? Or do we go
Yes.
to the applicant?
No, now this is the actual presentation. That was the introduction.
Oh,
Okay.
Yeah, just the way the pre-hearing order sets up, we get 10 minutes per intro
Got it.
presentation
Yep.
and our main arguments.
All right,
Details are ahead. Okay.
all right, very good.
All right, for the Division of Maintenance presentation, I'll explain the objections the application received and present the staff's recommendation. DRMS received comments from two agencies, Colorado Parks and Wildlife and the Division of Water Resources. We also received, the division also regarding the application received 33 timely objections from 30 individuals. That both jurisdictional and non-jurisdictional concerns were raised by the objecting parties. The division issued its recommendation, rationale for recommendation for approval on June 13th of 2025. And the pre-hearing conference was held on July 2nd, where 7 objectors attended and maintained their party status. The issues raised by the objecting parties were kind of grouped into the following 6 categories. Number 1, concerns regarding wildlife impacts, including the proposed installation of a sand processing plant in the future. Concerns regarding water quality and pollution from the dredged sediments. Concerns regarding the discharge of sediment into Lake Christina. Concerns regarding the applicant mining without a permit. Concerns regarding ecological impact. And concerns regarding the proper notification of the permit application and listing of BP Draw Farms Authority within Exhibit P of the application. So first concern, wildlife impacts, including the sand processing plant. So CPW provided feedback regarding the application in a memo back on January 4th of this year. Their primary concerns were regarding the future sand plant operation and its proximity and potential disruption to wildlife particularly for current and historic bald eagle nests, waterbird nesting areas, and the American white pelican nesting colony, all along the kind of the northwest and western shorelines of Milton Reservoir. During the adequacy review process, the applicants provided a technical memorandum addressed to DRMS and CPW, which included species activity mapping to identify buffer zones for different wildlife species. And some of the proposed affected lands intersect with those buffer zones. However, CPW's buffer zone protocols allow for operations that have historically occurred to continue, which includes the in-reservoir settling ponds, the northern settling ponds, stockpile 1, and the west stockpile. So on this figure, the figure on the left-hand side, this is for the great blue heron nesting area. And then on the right-hand side, this is for the white pelican nesting area. The blue line indicates these protection buffer zones. And as you can see, it does intersect. So I didn't kind of touch on this earlier, but this is the in-reservoir settling ponds. They were initially constructed to help with the processing of sediment and separation from sediment from water. But now they're really using these settling ponds on the northern side, so I didn't really touch that. But so yeah, these are the in-reservoir, these are the normal settling ponds. But as you can see, it does intersect with the in-reservoir settling ponds and stockpile 1, as well as future settling ponds. And then for the American white pelican, the buffer zone so shown here, and that really just intersects with the in-reservoir settling ponds. And then one more SAM map. So this map is for eagle nests, sorry, bald eagle nests. And you can see here, so right over here, this is nest A, nest B, nest C, and nest D. Now, and again, those do intersect with some of the active operations. But then worth noting, when the division conducted our pre-operational inspection on March 24th, this area points to a raptor species that we saw, and that species was observed in the nest A area by the in-reservoir settling ponds, and they seemed the applicant was actively mining. There were trucks, there were haul trucks, they were active at the time, and the bird seemed pretty undisturbed. So additional mitigation measures in the mining plan proposed by the applicant for wildlife impacts. Again, those CPWs, their buffer zone protocols allow for operations that have historically occurred to continue, which includes those in-reservoir settling ponds, the settling ponds, stockpile 1, and the west stockpile. The applicant will conduct nest surveys prior to any vegetation removal. The applicant has committed to avoiding disturbance to active nests and not conducting new surface disturbance beyond the existing operations during the active nesting season. The applicant has been issued an incidental take permit from U.S. Fish and Wildlife Services for bald eagles, which includes monitoring and reporting to USFWS. Important to note, after CPW's review of the applicant's technical memorandum, CPW stated that their concerns were addressed and did not have any further questions or comments. The applicant has fulfilled the requirements of Rule 6.4.8 regarding wildlife information. DRMS and CPW have reviewed the applicant's analysis of any wildlife impacts and mitigation measures and find the proposed operation complies with Rule 3.1.8. And the applicant has committed to submitting a technical revision to DRMS in the future before any sand processing plant is installed. Objection topic number 2, pollution and water quality. Concerns regarding water quality and pollution from the dredged sediment. The division's preliminary adequacy review letter requested characterization of the dredged material coming from the bottom of Milton Reservoir. Sediment samples were collected by Ecological Resource Consultants, a third-party contractor on behalf of the applicant. And those samples were collected from the existing stockpiles, Lake Christina, the Northern Settling Basin, and this was all in February and March of 2025. Those results were analyzed, or those samples were analyzed for recreate metals, volatile organic compounds, VOCs, and semi-volatile organic compounds, SVOCs, using synthetic precipitation leaching procedure. And those results were compared to CDPHE Regulation 41, the basic standard for groundwater. So these two figures show the sampling locations. Start on the south side. So over here, this is the in-reservoir settling pond. There's a sample there. And this is the stockpile 1, 2 samples there, and then one sample at the west stockpile. On the northern side, samples were collected from 4 from Lake Christina, these yellow sampling locations. These 2 blue indications, those are actually water quality samples. We'll get onto those later. Over here, these 2 sampling locations are kind of the outflow location from the cyclone. So after that material is pumped through the cyclone, you know, they collected a sample right after that material exits the cyclone. And then this over here, so initially the applicant had a series of historic catchment basins that they converted into more settling ponds that, you know, those are now dry, that they're no longer using, but the applicant did collect a sample, or the consultant did collect a sample at this location here. So the soil and sediment results, analytical results on the northern, just in general, for the existing stockpiles, the metal barium was detected below regulatory standards, and all other constituents that were tested were reported at concentrations below their method detection limits. For Lake Christina in the northern settling basin, so these 4 sampling locations and this one right here, arsenic, barium, chromium, and lead were detected below regulatory standards. 2 VOCs, dimethyl phthalate and vinyl acetate, were detected. But there's no regulatory standards to compare those two. You can see on this graph here, those are the concentrations that were detected, but there's no standard to compare to for Reg 41 standards. In addition, methylene chloride another VOC was detected above the regulatory groundwater standard in sample locations L3 and L4, so right in Lake Christina over here, as well as the northern settling basin. Again, you know, those 2 VOCs, dimethyl phthalate and vinyl acetate, that were detected, there's no regulatory standard to compare those two. Those compounds are not used by the applicant in any of their processes. And then for the methylene chloride that was detected in sediment samples above the regulatory groundwater sample of our standard of 5.6 micrograms per liter. Methylene chloride is typically used in paint strippers, adhesives, aerosols, pesticides, cleaning products, and drilling operations. And those materials are not used at all in the dredging process, and there's no chemicals that are added to the dredging process during dredging, dewatering, or stockpiling. And in addition, for the existing stockpiles, the analytical results were non-detect for methylene chloride. So the elevated concentrations of methylene chloride are not from Lake Christina are not attributable to the dredging operations. Regarding the water quality sampling, water samples were collected from Lake Christina in 2 locations and 1 in Milton Reservoir, and those samples were analyzed for metals, VOCs, and SVOCs. There was no VOCs or SVOCs that were detected. Metals were detected, but below regulatory standards. So sampling results indicate that sediment collected from the proposed permit area meet the standards set forth in Colorado Regulation 41, Table A, and Tables 1 through 3. In addition, the applicant will continue to monitor the physical and chemical properties of the dredged material and submit those results to DRMS. As part of their mining plan, they have proposed monthly sampling. They have a monthly sampling plan with the following analytes for total and dissolved metals, VOCs, total dissolved solids, and then SVOCs on a quarterly sampling frequency. And those analytical results and sampling will be submitted on quarterly reporting to DRMS. However, the applicant has committed to immediately notifying DRMS if any concentrations exceed Reg 41 standards. And then in addition, you know, surface water runoff is controlled, but kind of have addressed that more in later slides. So again, the dredged material, it's not contaminated with recreate metals, VOCs or SVOCs. And there's three VOCs that were detected in sediment samples from Lake Christina and the northern settling basin. They're not the result of the dredging operation. And the applicant will continue to sample and analyze the sediment generated from the dredging operation and provide the sampling results in reporting to DRMS. Objection topic number 3, concerns regarding the discharge of sediment into Lake Christina. So just to give a little bit of backstory, so I mentioned earlier those historic catchment basins that were converted into settling ponds. That's located, so on this figure right over here, so kind of right over, right over there. And it's kind of right along this is again the Evans #2 ditch, which is pretty crucial here. And then this is Lake Christina. Lake Christina is owned, it's on a parcel that's owned by BB Draw Farms Authority. And as part of their initial mining plan, they were, dewatering, that sediment in those settling ponds over here. And there was a period of time where they discharged, excess, they discharged into the Evans #2 ditch, and the Evans #2 ditch does discharge into Lake Christina. And so there was a time when discharge material from the applicant went into Evans #2 ditch and subsequently Lake Christina. However, the mining plan has been revised to no longer discharge any material into the Evans #2 ditch, only discharge water back into Milton Reservoir.
A question on that.
Yes.
When you said there was a time, you mean in their mine plans or physically existing?
It happened.
Okay,
It has happened. There has been material that has discharged directly into Lake Christina as the result of their dewatering processes.
okay, thank you.
Water, not sediment.
It's like a, it's kind of both. It's,
Slurry or something.
Yeah.
Okay. Got it.
Now, according to the applicant, again, Lake Christina has been receiving inflows from the Evans #2 ditch for decades. I have here, and these are historical Google Earth imagery that kind of reinforces this assessment. This is from 1999. This figure is from 2011, and this figure is from 2024. So over here, so this is the Evans #2 ditch running parallel to the Lake Christina, and then you can kind of see over here, right here, this is the discharge point where the Evans #2 ditch does discharge into Lake Christina. And you can see a notable sediment fan that radiates out from that discharge point. So, that's been happening for decades. And
Is that like a formal head gate, or is it just like a leak in the ditch? I mean, it's deliberate. Or was deliberate.
Yeah.
If I recall from our inspection, the ditch just kind of flows into it, and then there's another outflow at the southern end of the lake.
It doesn't solely discharge into Lake Christina. It also discharges into the Gilmore ditch.
All right.
We can cover that for you as well when that.
Okay. When the division conducted our pre-operational inspection on March 24th, we did observe this material. So this is Lake Christina, and now it's just on the southern side. You can see this is now the applicant Frico is excavating that material, and you can see the extent of their excavation at this time. So they are excavating the discharge material as part of an agreement with BB Draw Farms Authority. They have a formal agreement to do that. And what they are doing is they're excavating that material and transporting it onto the Frico, within the proposed permit boundary. And over here, this is the material. This is where it's part of the mining plan. They will reclaim that. When the division observed it, that material is mostly kind of a brown clayey sand with kind of no discernible staining or odor. Again, so yeah, the reclamation plan has been updated to indicate where the excavated material will be transported to. So this is there's the stockpiles and 1 through 4, and there's Lake Christina. There's the Evans #2 ditch, and they're just doing it over here. That's where they're going to reclaim it. They're going to grade it, have it match the existing topography, and then have topsoil replaced and then seeded. Now, CDPHE was notified regarding this discharge of the material into Lake Christina, and they subsequently issued a compliance advisory to Frico on May 15th of this year. They requested Frico apply for an alternative stormwater discharge permit. They previously held a CDPS general permit for stormwater discharges associated with construction activity, but it wasn't really for. But this other permit would be for, to my understanding, would be for discharge from sand and gravel mining or industrial stormwater. The applicant has revised their Exhibit M, other permits and licenses, to reflect this change, which fulfills the requirements of Rule 6.4.13. So, kind of in summary, the applicant revised their mining plan to no longer discharge any material into the Emmons number 2 ditch, which does subsequently discharge and flow into Lake Christina. The applicant has an agreement with BB Draw Farmers Authority to remove the discharge sediments that is currently in Lake Christina. That excavated sediment will be placed within the proposed permit area and will be reclaimed according to the reclamation plan. And the applicant is working with CDPHE on obtaining the appropriate discharge permit. Objection topic number 4, mining without a permit. The applicant did mine without a permit. So on July 31st of 2024, the DRMS received an inquiry from Weld County that FRICA was selling sand dredged from Milton Reservoir and selling it off site, and all without a reclamation permit. The division responded by conducting our inspection of the area on August 8th. And then on August 19th of 2024, the DRMS issued an inspection report that cited a possible violation and that required corrective actions. The possible violation was for CRS 34-32.5, parent 109, parent 1, for engaging in a mining operation without obtaining a permit beforehand. The corrective actions included FRICO immediately cease selling that dredged material off-site, and that they must submit a 112C permit application for construction materials to DRMS by the deadline of November 22nd, 2024.
I believe a board member has a question.
Oh, no, it's just
That's just the mouse. Okay, my mistake. Okay, sorry.
Does anyone have any questions? Okay. Okay, well, yeah.
Real quick, Lake Christina is that on private property? Is that a
Yeah.
private lake or is that a public?
It's a public lake, owned by, on the parcel owned by BB Draw Farms Authority.
So it is owned
Owned
by the same company that is the or
No,
the
no.
property, I'm sorry, the property is being.
The residential subdivision that is adjacent to the proposed mining operation.
Okay.
Pelican Lake.
Yeah, that's the
So, and so Lake Christina is outside the mining permit,
yes.
and they're basically the situation now is they have an agreement to remediate what's already been put in Lake Christine, bring it back onto the mining site.
Yes.
Is that I understand?
Yes. Okay, back to the mining without a permit. We had for the corrective action, FRICO needed to submit the 112C permit application by November 22nd, 24. They had, and their consultant had reached out to DRMS, many times in September and October to make the application was just to try to get information regarding the application and the requirements. And then FRICO subsequently submitted that permit application on November 12th. Objection topic number 4, ecological impact. Oh, sorry. Number 5, sorry. Again, the impetus of this dredging operation was to remove excess sediment that had accumulated on the reservoir floor since the early 1900s and increase the water storage capacity of the reservoir to help prevent for better water storage and beneficial use for Weld County and Colorado as a whole. So for the ecological impact, so the stand stockpiles, they will be watered down using water trucks for dust suppression during the active placement of material as part of their mining plan. A biodegradable, water resistant, and environmentally friendly soil binder will be applied to those stand stockpiles to help control and prevent wind and water erosion. And then for the stand stockpile, the slopes and the top, those will be vegetated. As another after material is done being placed on those stockpiles as another form of erosion control. And then the stand stockpiles will be monitored monthly and have additional application of the soil binder applied as needed. And then another thing for they have a dredging operations, a small staging area right along the shoreline of Milton Reservoir, right next to the cyclone. That area that will be completely removed, as well as all the equipment there, as well as the future sand plant. All equipment and everything will be removed during reclamation. So the mining plan addresses grading and control of erosion and siltation of the affected lands and protection of outside areas pursuant to Rule 3.1.5, Parent 3. Just wanted to really emphasize that if the applicant is granted a DRMS permit, they can resume selling that dredged material off-site which they've been unable to as, at this time. Which if they can sell it off site, then they can reduce the size of the stockpiles or them altogether. For these reclamation plan maps, for stockpiles N1 through 4, I mean, this is really like a worst case scenario that they don't sell the material, that they have to stockpile it, leave it on site. They will have it, no greater than 3 to 1 side slopes for the stockpiles, will be revegetated as another form of erosion control. And then for the settling ponds, part of the reclamation plan, if they do have additional sediment left over that's not sold, they'll also backfill those reservoir basins with that material and then just grade it. However, if they don't sell that material off, or if they sell everything off and there's nothing to backfill the settling ponds with, they will tear down the embankments that separate these ponds and then just finish grade and revegetate. Objection topic number 6, Exhibit P, concerns regarding the proper notification and listing of BB Farms Authority within Exhibit P pursuant to Rule 6.4.1, 6.4.16.1. Regarding the pursuant to Rule 1.6.2 for the notice regarding the application, the applicant mailed notice of the application to all owners of record within 200 feet of the boundary of the affected lands and provided certified mailing receipts of those notices. They held a public notice publication within the Greeley Tribune on 4 different publication dates, seen up there, January and February. And then 20 days after that final publication, the public comment period ended on March 7th of this year. In addition, they have 5 mine entrance signs and mine entrance notice signs were posted around the proposed permit boundary. Those are kind of located they're located in kind of cardinal directions, a couple on the east side, by the mine entrance, the north side. So,
just a quick question: are those public notice, the letters, are they part of our bookmarks in this packet? I didn't see them called out specifically, but they might.
I think they're probably in the way back. They should be in the back.
As in a.
They should be, because those are part of the adequacy response.
Okay, it's part of the adequacy as well.
Yeah,
Okay.
so the
Proof of filing adequacy response, or like 013A or B, somewhere in there. County clerk, I see county clerks, proof of publication, but I didn't see actual letters or receipts. We usually have the green certified mail receipts.
I will be reducing those as part of our case.
Okay, it's nice to have them in the packet. First thing I look for.
Okay, just continuing, there's Milton Reservoir and the proposed mining operation, and then this white shaded region is the kind of the approximate location of BB Draw Farms Authority, also known as Pelican Lake Ranch. So that's its proximity to the proposed mining operation. So the applicant provided the following explanation for not listing BB Draw Farms within Exhibit P and listing it as a municipality and not listing it as a municipality. So the BB Draw Farms Authority was formed by agreement between 2 metropolitan districts that were formed pursuant to Title 32 CRS. BB Draw Farms Authority is not constituted as a municipality because municipalities are created pursuant to specific procedures and requirements set out in Title 31, Article 2 CRS. Those requirements and procedures do not include agreements authorized by CRS 21-1-203. So the applicant has complied with Rule 6.4.16 regarding exhibit. And then objections that were raised that are non-jurisdictional to DRMS are listed here, including aesthetic impact of the mining operation, quality of life, property value, dust and air pollution, light pollution, a property transfer, truck traffic, noise, and then and then concerns regarding a conflict of interest between the general manager for the applicant and his role as on the BB Draw Farms Authority board. Questions? Yes.
It's non-jurisdictional to DRM who dreams, so none of those are concerns that we should be addressing.
Yeah, I mean, there's no rule that I can point to that would provide relief for those specific issues. These issues are typically addressed at the county local permitting. This is always kind of a sticky subject. You know, we say they're non-jurisdictional. It sounds cold, and it's not like we don't care about those, but we just have no regulatory mechanism to enforce anything regarding those.
But the county could.
Yes. Yes.
I have a couple questions going back a ways.
Sure.
Just, historic, or having this mine going on without any permit, is there a set violation fine for doing this without getting a permit? What, going through the process of getting it is good, but is there anything that we do for just violation of not having a permit?
Yeah, in this case, you know, typically when we come across these types of issues, specialists go out, we do our inspection, we collect our information, we bring it back to management, we discuss the proper course of action. You know, as the board knows, these reservoir dredging and filling operations have kind of become a question, you know, broadly. And we used our regulatory discretion to try to get these types of operations into compliance as quickly as possible. We had an operator who was willing to work with us. They didn't fight us. They willingly, as soon as we let them know that they needed a permit, they diligently pursued getting an application together. The application they submitted in November, as you saw in the packet, it was quite a lot of information, a lot of material that they supplied in a very short period of time. So they were willing to work with us. And we chose to go that route as opposed to bringing it to the Mineland Reclamation Board for a formal hearing for an enforcement action.
So just to follow up on that, essentially, you kind of went through the is it mining question. The is it mining is because the material was sold off-site.
Yeah.
That's what indicates what triggers is it mining.
There's a number of aspects that get taken into account with that is it mining form, and that is definitely one of them.
And so part of it, this is Russ Means for the division. Part of that too and stuff is in our weighing out what course and stuff to take is not only you know, what the disposition of that material is that's being removed is going to be, whether it's going to be a short term, having a stockpile, a small amount of that, and then it's gone and stuff, and what's going on there versus like this that has a 20-year, a potential 20-year project and stuff with selling material and introducing it into the market. So those are all kind of some of the aspects and stuff that we take a look at and stuff when we're looking at this. And I think the biggest trigger and stuff here and stuff for us was that we had in our review of this was we had applicant and stuff and that or operator and stuff that was willing to work with us. They immediately stopped selling material until such time and stuff as they obtained the required permit and stuff. So,
But it's still dredging. Is the operation still going on? They're just stockpiling instead of selling.
Correct. Yeah, my understanding is they're still dredging. They're still stockpiling.
So maybe the applicant is going to address this, but it was the primary purpose to increase water storage, or was the primary purpose to sell material?
Yeah.
The applicant can probably speak to that better, but that is our understanding.
yeah,
I'll address it, but to answer your question quickly, it's to increase the storage capacity of the reservoir, to get more water to farmers.
Yeah.
Yes.
and that's one of the things we take a look at and stuff, but that is the overall benefit of the community and what the project really is. So, yeah.
And they can speak to it more, but their application included characterization or I guess, like that, they determined that the sand that was being dredged was a saleable commodity, so then they might as well just sell it and move it off site.
Yes.
So.
Going back again, wildlife impacts, there's no information about what happened before CPW got in there to evaluate what's going on now.
You know, recalling, you know, mining from 2021 has historical operations that have been operating for the last 5 years. We're kind of dead, you know, they abided by that. So that's kind of that, you know, clarification.
Okay. Anybody else? Okay. Okay. Let's move on to the applicant.
Good morning again, and for the record, my name is Philip Lopez. I'm an attorney with the law firm of Fairfield and Woods here in Denver. My bar number is 40484. I'm the attorney representing applicant Farmers Reservoir and Irrigation Company, referred to as FRICO. Just a quick overview of what we're going to go over today. I'm going to put up 4 witnesses today. I'm going to put up Scott Edgar, who is the general manager of FRICO, and 3 experts from ecological resource consultants who worked on the application, so that hopefully they can answer any questions that you may have. So without further ado, the first witness I'm going to call is Ms. Heather Thompson, and she's joining us via remotely. So if she's ready, I think we can get started.
Good morning. I hope everyone's hearing me okay.
Yes.
Great, great.
All right, if you can just give me a second to get my exhibits ready to go. There we go. Okay. All right, can you please state your name and spell it for the record?
My name's Heather Thompson, spelled Heather, last name spelled Thompson.
And where are you currently employed?
Ecological Resource Consultants.
And what's your current position there?
I'm a senior project manager.
And what is your educational background?
I have a BS in civil engineering from Cornell University and a master's in water resource engineering from University of Colorado.
And are you a licensed professional engineer?
I am since 1998.
And how long have you been with ERC?
Since 2006.
And what type of engineering work do you do at ERC?
I'm a water resource engineer. I work for a variety of private and public companies. I work for Farmers Reservoir and Irrigation Company. I work on a variety of different surface water hydrology projects, surface water modeling projects. These projects involve drought analyses, yield analyses, water supply operations studies. I also work on a variety of different water rights investigations, primarily providing engineering support for water court applications. Those applications involve augmentation plans, exchanges, new water rights such as storage rights or direct flow rights. I also do quite a bit of work in environmental permitting for large reservoir supply projects.
And how long have you been a consultant for FRICO?
Since 2006.
Okay, and you do all of those tasks that you just described for FRICO as well?
Yes, primarily water rights investigations and water operations and supply investigations.
And have you testified as an expert witness in the prior court proceedings?
I have in 2 cases. The first was 02 CW 403 and the second was 16 CW 3052.
Okay, and to the extent it's necessary, I'd like to qualify Ms. Thompson as an expert if the board is inclined to agree to that. All right, and her expertise is in water resources engineering. Okay, so Ms. Thompson, let's just kind of get to the meat of this. Can you just describe to the board what FRICO is and does?
Sure. FRICO is a mutual ditch company. It operates 4 main divisions, which are each centered around a lake. Those divisions include Marshall, Stanley, Barr, and specifically in this instance, the Milton Lake Division. FRICO operates a variety of different facilities, canals, lakes, and headgates to deliver water to shareholders of each of these divisions.
And can you take a look at Exhibit 2 that's on the screen here?
Yes, this is the system map for FRICO's 4 divisions that I just mentioned. And the green lines here show the various canals that FRICO operates, and the darker green and shaded areas are the 4 lakes that I just mentioned.
Okay, and I'm going to zoom in, if I can, over here to Milton Lake so that we can show the board the situation that we're dealing with here. Can you just really quickly describe how the Milton system works?
Absolutely. Milton Lake is the primary regulating facility for the Milton Division. FRICO diverts water from the South Platte River via the Platte Valley Canal. That water is delivered into storage in Milton Lake. FRICO also has the ability to divert water from what is called the Burlington Canal, which head gate is located further south on the South Platte River. Water diverted at that head gate can be delivered through Bar Lake and into what's called the BB Canal and can be delivered to Milton Lake from the south. And then the primary canal that FRICO uses to deliver water from Milton to its shareholders is called the Gilmore Canal, and that exits Milton Lake on the north side of the lake.
Does Milton Reservoir have a water court decree for the water that it stores in the reservoir?
It does. It is the 1909 storage right is its original storage decree for the reservoir. And what you're showing here in this exhibit is the original decree in case CA 54-658, I think.
Okay, and this is the most senior storage right for Milton Lake?
It is. The court entered this decree in 1924, but the water right has an appropriation date of May 29th, 1909.
Meaning
Frank-
that the water was actually diverted into the reservoir starting in 1909?
That's correct. The reservoir was actually constructed in 1909.
And what was the original capacity, decreed capacity of the reservoir?
FRICO has the ability to divert water to fill the lake up to 26,773 acre feet. That's the original storage decree.
Okay, and does Milton Reservoir currently have a capacity of 26,773 acre feet?
It does not.
And why not?
The canals that I just mentioned that FRICO uses to deliver water into the lake are earthen canals. And so when diverting water from the South Platte and from the irrigated lands that surround the reservoir, there's a lot of sediment that is carried into the lake via those canals and from runoff into the lake. And that sediment has filled in a certain portion of capacity in the lake.
So prior to the time that FRICO began dredging the reservoir, what was the capacity?
The capacity was approximately 21,695 acre feet. FRICO actually has the ability to store slightly more than that because that is the elevation up to the service spillway. They can store slightly more than 21,000 acre feet, but only on a temporary basis and if they exceed the elevation of the service spillway.
And does FRICO currently have enough water rights to meet the irrigation demand for its shareholders?
It does not.
Has FRICO obtained any additional rights other than the original 1909 right for Milton Reservoir?
It has. There are several decrees associated with Milton.
Okay, let's go to Exhibit 7. Can you identify that document?
This is the engineering report for a conditional first enlargement storage right and an absolute and conditional refill right in Milton Lake. This was the expert report that I prepared for case number 22 CW 3102.
All right, and that's a court case going through water court at this time?
It is.
Let me draw your attention to Table 1. Can you describe for the board here what you're looking at Table 1 of that report?
Table 1 is a summary of all the water rights that are associated with Milton Lake. As you can see in the table, there are 6 rights associated with the lake. There are 3 storage rights. The first that is listed here is the Milton Lake storage right. That's the senior water right that I just mentioned. There are 2 additional storage rights, which are the 5th and 6th listed rights in this table. The 5th is the Milton Lake seep right, which was decreed in 16 CW 3052, and then a recently decreed right called the Bennett right, which is actually for a gravel pit that is located along the South Platte River, which FRICO can store water in and then relocate into Milton Lake. The other 3 rights in the center of the table, the Milton Lake direct right, the 84 CW 90 right, and the 2002 multi-purpose right are direct flow rights. What that means is FRICO can divert these rights, deliver them through Milton Lake for direct delivery to the shareholders below the lake.
All right, and you had mentioned the Milton Lake seep right, and is there a decree for that water right?
There is. The decree was entered in case 16 CW 3052. The volume of the right is 4,563 acre feet.
I'm going to pull up Exhibit 4 of applicants' exhibits. Can you identify Exhibit 4?
This is the findings of fact, conclusion of law, and judgment of the water court in that particular case, 16 CW 3052.
And did the water court make any specific finding to FRICO's needs for water, additional water in that case?
They did, as you're showing here in this paragraph. I'll just read the paragraph. It states FRICO is a water short system, meaning that shareholders do not receive enough water from all sources presently available to meet the consumptive use needs of their crops. Even with the addition of the seepage water sought in this case to the supply, FRICO shareholders will still not have enough water to meet the full irrigation needs of their crops.
Okay, so can FRICO use the seepage right in addition to the original Milton 1909 right?
In most circumstances, they can't. And the reason for that is the decree in that particular case includes a limitation, which is referred to as a one fill rule or one fill limitation. FRICO is limited to filling the lake with either its 1909 original storage right or the seepage right. So it does not add to the supply. It only adds to the supply when FRICO wouldn't otherwise fill the lake with just its senior right. So it just it provides supply only when the 1909 storage right is not sufficient to fill the lake on its own.
Great. And so in response to FRICO's limitation on only using the seepage right in conjunction with the senior right, what did FRICO do after that to address that situation to get more water to its shareholders?
FRICO decided to dredge the lake. So the purpose of the dredging project was to enlarge the lake first so that it could be able to store the full measure of its senior water right up to 26,773 acre feet, and then to enlarge the lake by an additional 7,227 acre feet up to a total volume of 34,000. That's the enlargement portion of the project.
And let me draw your attention to Exhibit 6. Can you identify that exhibit?
Sure, that is the application for the absolute and conditional water rights that are associated with the enlargement that I just mentioned. That is in case 22 CW 3102.
Thank you. And I realize now that I had not asked the board to admit all of those exhibits that I had previously brought up. So I would ask if the court would, or the board would admit those into your record.
Under the APA, everything presented to or considered by the board as part of the record. So yeah, we're good.
Makes it much easier.
Yep.
Okay, can you briefly, Ms. Thompson, can you briefly describe, maybe you already did, I might have missed it, but very quickly, what the application in this case is asking for?
Sure, and it might be helpful if you just pan down a little bit. We can look at paragraph 8, I think, is what describes the water rights that are being sought in the case. Right there, that's great. So first, again, the purpose of the project is to dredge and remove the sediments that had filled in the lake so that FRICO can store its full senior water right in the lake for the 26,773. And then if you look in paragraph 8.1, this is the enlargement right they're seeking for 7,227 acre feet. With that enlargement, that would bring the capacity of the lake up to 34,000 acre feet. So the second right they're seeking is in paragraph 8.2. That's the Milton Lake refill right. So they're requesting a refill of the entire capacity of the lake up to 34,000 acre feet.
And so just to quickly summarize all of that, so dredging Milton Reservoir is necessary to provide space to divert more water to meet the demands of FRICO shareholders.
That's correct. This is a water supply project to enable them to use their full senior water right. But the main impediment right now for FRICO in terms of being able to meet additional demands, irrigation demands of their shareholders, is the capacity of the lake. So they're looking to enlarge the lake to provide additional supply for their shareholders for irrigation use.
As part of the application for this, the RMS permit, did the Division of Water Resources provide any comments?
They did. They provided a letter requesting additional information regarding whether or not the dredging operation would expose groundwater and thus require a well permit and an augmentation plan.
And did ERC provide any response to Division of Water Resources?
Yes, I prepared a technical memorandum with information related to groundwater levels and so forth in the area of Milton Lake, essentially demonstrating that the dredge operation would not expose groundwater and therefore an augmentation plan and a well permit were not required.
And really quickly, Exhibit 13 on the screen, that was Division of Water Resources request for that information.
That's correct. That was the comment letter received from Division of Water Resources.
And Exhibit 14 is your response.
That's correct. This memorandum is my response to Wenley Dickinson with DWR.
Okay. And did DWR respond after you provided that technical memorandum?
Yes, DWR, Wenley Dickinson specifically sent me an email essentially stating that the information that I had provided demonstrated that FRICO would not be exposing groundwater with its dredge operation and that an aug plan and a well permit was not required.
And that is shown on Exhibit 15 that I have on the screen here.
That's correct. That email was from Wenley to myself.
No further questions from me, Ms. Thompson. The board or some opposers may have some questions for you though.
I have a question about the 7,000, how many additional request? So it's not a current water right, it's
correct
requested. I'm just guessing there will be a lot of years when that water won't be available. So the reservoir might be able to fill some years, but not a lot of years when there isn't that much water. Because that water right is current, so that doesn't mean it has any senior authority.
I'll let Ms. Thompson address that because she's by far the better expert than me on that.
Sure. FRICO typically fills its lake every year right now at Milton Lake, even in pretty dry years. There's been a few years, very dry years, that FRICO has not been able to fill the lake at its current capacity. So you're correct. In very dry years, FRICO will not be able to fill this junior water right. But in most average and certainly in wet years, FRICO will be able to fill the lake to a capacity of 34,000 acre feet. And a lot of that has to do with the water supply that is available in the BB draw, which is a source of supply for these for this new water right, and where calls typically originate on the South Platte during the winter. Even this winter, for example, there were periods of what's called no call. And during those periods of no call, FRICO could be diverting water under this new junior water right to fill the lake.
Any further questions?
This is Kim Coleman. Can I ask a couple questions?
Of course.
So in your 2025 memo, it claims no groundwater exposure, but test pits were only dug to 10 feet. Is that correct?
They were dug along the perimeter of the lake, yes, to approximately 10 feet. I think that was correct.
And then groundwater was later found at 16 to 20 feet?
We examined groundwater wells in the area of Milton. I can't recall off the top of my head what all the groundwater levels were. I'd have to take a look at, there's a table in my report if that could be shared on screen.
I just want to know how that is. I'm showing that no possible exposure to water depths up to 20 feet.
That's correct. Based on the dredging operation, the majority of the additional depth that's going to be dredged at Milton is not digging deeper as opposed to removing sediments. So they're kind of creating a bathtub, so to speak, as opposed to going much deeper. They're removing sediments and extending that level back. So it's almost going to be like a rectangle, so to speak.
Thank you. And then I have one more question. So on that permit that you filed to increase the water holding, is that typical general maintenance on a reservoir?
I'm not sure I'm following your question exactly, but it's not uncommon for water providers to apply for new junior water rights, whether that be for an expansion such as this project or to add water rights with different uses. In this case, FRICO's got the same use, irrigation, but enlargement rights are not uncommon at all in the South Platte Basin.
Okay, but this project is not typical general maintenance on any reservoir. This is actually an expansion project.
Well, I would say it's kind of both, right? It's a maintenance in the sense that it's dredging material to enable it to store its original senior water right, but then is an expansion on top of that.
Okay, thank you.
Ms. Thompson, let me just make a follow-up question to make sure the record is clear here. Is it your understanding under Colorado law that no water court decree is needed in order to recapture lost capacity due to sediment?
That's correct.
So to the extent that FRICO was not seeking an enlargement, FRICO would not have to go through any legal process in order to recapture its lost capacity.
That's correct.
Any other questions? All right. Thank you, Ms. Thompson.
Thank you.
All right, the next witness for the board is Mr. Scott Edgar, who's also appearing via Zoom.
Good morning, everyone. Can you hear me okay?
Yes.
Oops. All right, can you please state your name and spell it for the record?
Yes, Scott Edgar, SCOTTEDGAR.
And where are you currently employed?
The Farmers Reservoir and Irrigation Company, also known as FRICO.
And how long, what's your current position there?
General Manager.
And how long have you been in that position?
14 years, 1 month.
And what was your occupation prior to being the FRICO General Manager?
I spent 12 years working for Division of Water Resources as a water commissioner in the South Platte Basin.
And can you briefly explain your duties as the FRICO General Manager?
I handle all day-to-day operations of the company. I've got 55 full-time employees, manage a reservoir system that stores a little over 100,000 acre-feet of water. We have 400 miles of ditches. We supply water to municipalities with a little over 600,000 municipal customers, and also provide water for about 100,000 acres of irrigation.
What's your primary goal or duty as the FRICO GM?
To summarize it as briefly as I can, to provide the FRICO shareholders the maximum amount of water physically and legally available at the lowest cost possible.
And you just heard Ms. Thompson's testimony, I assume?
Yes, I did.
And do you agree with Ms. Thompson's testimony that the reason for the dredging project is to recover the original lost capacity due to sedimentation and to enlarge the reservoir to provide more water for shareholders?
Yes, I do.
Was Milton Reservoir originally constructed and owned by FRICO?
Yes, it was constructed in 1909.
And it's still owned by FRICO?
Yes, it is.
And all the water that's stored in Milton is diverted under water rights owned by FRICO?
Yes, from the South Platte and from seepage in the BB draw.
When did FRICO begin to dredge Milton?
In 2021.
And is it your understanding that FRICO does not need a DRMS permit simply to dredge Milton in order to recover its lost capacity?
Yes, it is.
So when FRICO began dredging Milton, was there any thought or intent of selling the material that was dredged from Milton?
Nothing concrete. The primary purpose was to excavate the reservoir for additional water supply. Once we were a couple years in and had some pretty large stockpiles built up, began exploring how to get rid of the material.
Can you briefly explain, just very quickly, kind of the operations of the dredging project?
Sure. So as Chris said, it's a giant pontoon, 2 motors, about 2,000 horsepower, pumping the slurry. So it's about 80% water, 20% solids, through a couple miles of pipe. that then dumps up to the cyclone. The cyclone removes about 80% of the water and dumps all of the solids down on the bottom, on the ground below the cyclone. The water and some of the fine material goes into an overflow that we're pumping over to settling ponds. Once those settling ponds fill up, we let them dry out and excavate the material out of the settling ponds.
And we'll get to this a little later, but water from the material that separates in settling ponds, that returns to Milton now, right? Milton.
Yes, that's correct.
Okay, can you explain to the board how FRICO got to the point of selling the dredge material?
I was contacted by an employee of one of the oil and gas operators, asking if they could buy material to use for reclamation material. They had a tank battery that they had contamination, so they had to remove the contaminated material and bring in clean fill. So we started selling the material, I think last June, primarily to the oil field for reclamation projects.
And when FRICO began to sell the dredge material, why didn't FRICO apply for a DRMS permit?
Prior council advised that if we weren't dredging the reservoir primarily to sell the material, that we didn't need a mining permit.
And so now is it your understanding that DRMS believes a permit is required even if selling the material is not the primary purpose for the dredging project?
Yes, it is.
So after you begin selling the dredge material, you were then contacted by DRMS?
Yes, DRMS came out and did an inspection last summer, informed me that they believed we needed a permit to continue to sell the dredge material.
And what did FRICO do in response?
Excuse me, shut down sales of material that afternoon, and we've not sold material since. We also submitted the application last November for this project.
Okay, and so once FRICO dredges enough material to regain its lost original capacity, it intends to continue dredging to enlarge the reservoir?
Yes, as Ms. Thompson testified, FRICO plans to enlarge the reservoir. We're in the process of getting a new junior water right to meet the irrigation demand for our shareholders.
And you're aware that there's been various objectors that have raised some concerns to FRICO's application?
Yes, I am.
And let's just go over those really quick. Did FRICO provide the required notice of its application?
Yes, notice was published as required.
Okay, and I'm brought up exhibit 10. Oh, I thought I did. Okay. Can you identify exhibit 10?
Yes, this is the notice that was published.
I'll note that there's the public notice there. Did FRICO provide notice to landowners within 200 feet of the boundaries of the affected land as required by statute?
Yes, we did. We mailed letters out to all of those landowners, the mineral owners, easement owners.
And I'll point your attention to exhibit 11 on the screen. Can you identify what those are?
Yes, those are the receipts showing the certified mailing that went out.
Okay. There's a lot of them.
Quite a few, yes.
One opposer has raised the concern that FRICO's application did not include the BB Draw Farms Metro District pursuant to Rule 6.416 that requires municipalities within 2 miles be listed. Can you explain why FRICO did not list BB Draw Farms Metropolitan District in its application?
Well, first, BB Draw Farms Metropolitan District is not a municipality. It's a special district created under different statutes than a municipality. The district was set up for development of Pelican Lake Ranch, which is the residential development to the west of Milton Reservoir. There are actually 2 Metro District out there. Metro District 1 is comprised of the lots owned by the individual lot owners. Metro District 2 is owned by the developer, or is the land owned by the developer. Once land is platted and developed, it's moved out of District 2 into District 1. There's also an authority which sits over the top of the two metro districts and is represented by two members of Metro District 1 and two members of Metro District 2. And that's the BB Draw Farms Authority, which is the owner of Lake Christina.
I figure that's what I was just gonna ask you. So the authority is the owner of Lake Christina. It's not that the lake is owned by any of the individual homeowners in Metro District 1.
Correct.
As part of its application, did FRICO submit a letter from its council regarding the fact that BB Draw Farms Authority is not a municipality as required under section 29?
Yes.
And showing exhibit 34, is that letter?
Sorry, Phil, I don't see it.
Technology. There we go.
Yes.
Okay. And that was provided with your application?
I think it
Or
was
response to
one of
the
our
application?
responses back to an adequacy review letter from DRMS staff.
Has FRICO made any efforts to reach out to the residents in BB Draw Farms Metro District number 1?
Yes. Back in March, I did a town hall type meeting. I think there were over 25 people in attendance and another 15 or 20 online. I gave a presentation of our project.
And has FRICO made any efforts to reach out to any opposers who are not residents within Metro District 1 or reside elsewhere?
Yes. I've met with two of the landowners that are south of the plant site and coming up with a way to address their concerns.
Does any of the land where the material will be stockpiled or processed belong to any residents within the number 1 district or any of the other opposers' lands?
No, the land being used will either be owned by FRICO or by REI LLC.
Okay. And can you briefly describe to the board what REI LLC is?
Yes, I can. REI LLC is the developer entity formed by a group of investors to develop Pelican Lake Ranch subdivision. FRICO owns the controlling interest in REI as of 2022. And all of the land owned by REI is in Metro District number 2.
And does FRICO have any agreement with REI LLC to stockpile?
Yeah, we have a couple of them.
Okay, let me pull them up here. Can you identify exhibit 21?
Yes, this is an agreement from 2022 where REI gave FRICO permission to, or it's a lease, to use the land for the stockpiling.
And has there been any amendments to that agreement?
Yes, we did an amendment in 2025. It was brought to our attention that a small piece of land was left out of the original agreement. That was not the intent. So the members of REI, which are, excuse me, the decision makers for the LLC, signed the amendment tying that new land in.
Great. Let's shift gears here really quickly and talk about Lake Christina. Can you please describe what Lake Christina is and where it's located?
Yes, so it's just north of Milton Reservoir. Chris had a good map earlier that showed where that's at.
I'll pull up ours here.
Excuse me.
I said I'll pull up our map here real quick.
Thank
I
you.
don't know if it shows Lake Christina. It might. Oh yeah, it does. All right, can you see that?
Yes, so it's just on the north end of Milton Reservoir. So the Evans number 2 is a direct ditch. What that means is water is diverted at the South Platte River. The ditch rider for the Evans number 2 delivers water along the course of the ditch to their shareholders. Other than Lake Christina, there's nowhere else for that water to go. So the ditch rider has to make sure to have minimal flow going into Lake Christina. So there is, Lake Evans number 2 terminates at Lake Christina. That is owned by a different ditch company, Platte Valley Irrigation Company. And then Lake Christina on the south end has an overflow where once Lake Christina is full, water spills out and spills over to Frico's Gilmore Canal, which is the canal that we release water out of Milton Reservoir to.
And just to clarify that Frico has no control of water that the Platte Valley Irrigation Company diverts through the Evans number 2 and discharges into Lake Christina.
That's correct. It's a separate company, separate staff.
And the land where Lake Christina is located is owned by the BB Draw Farms Authority.
Yes, that's correct.
And are you aware that some opposers have raised concerns about the discharges into Lake Christina from Frico's dredging project?
Yes, I am. Last summer, when we were dredging in 2024, some of the water from the underflow material, which is the material that comes out of the bottom of the cyclone, it does have some water in it. That was directed down to a low detention basin area that then overflowed into the Evans number 2, and that carried water with some material into Lake Christina. After the residents of Pelican Lake Ranch raised concerns over that, first, Frico changed its operation for the 2025 dredge season, and we directed that underflow water back into Milton Lake. So no water or material will be directed to Evans number 2.
Has Frico entered into any agreement to remove any sediment that possibly got in there from the dredging?
Yes, on March 6th, Frico entered into an agreement with BB Draw Farms Authority to go remove the material out of Lake Christina that was attributable to Frico's operations from 2024.
And Exhibit 35 shown on the screen, is that agreement?
Yes.
All right, just a couple more questions, Mr. Edgar. So if the board were to deny Frico's permit, what would be the effect, assuming Frico needs a permit to sell material, even if it's not the primary reason for dredging the reservoir?
We would continue to dredge the reservoir to recapture the lost capacity, but we would not be able to sell the material, so the stockpiles would continue to grow in size and scope.
And if the board were to grant Frico's permit, what would be the effect?
We can begin selling material again, which would decrease and ultimately eliminate the stockpiles. After all stockpiles are eliminated, then all the land will be reclaimed.
Great. And I'm going to ask you a very quick series of questions, which are going to sound very boring, but it's for the purpose of making sure that all the statutory requirements here are met. Frico has no issues paying a financial warranty for its proposed remediation plan?
No, it does not.
And Frico has paid the required application fee?
Yes, it has.
Is there going to be any effect on the stability of any significant permanent man-made structure within 200 feet of the project?
No.
Is there any of the land within the project scope within a wildlife refuge or other national system?
No.
Are any of the lands at issue within a recreational facility established pursuant to Title 29, Article 7?
No.
Are any lands at issue within the boundaries of any park and recreation district established pursuant to Title 32, Article 1?
No.
And are any of the lands at issue within a state park system?
No.
All right, and I have no further questions, Mr. Edgar. Thank you.
You're welcome.
I have a couple questions if I can ask.
Yes.
So Scott, I think this is Kim Coleman, a resident at BB Draw Farms. So while you were making these big stockpiles of sand, were you protecting any of the neighborhood prior regarding erosion and sand suppression before now?
Yes, we've been applying water on the area to try and keep dust down.
And that's just on the roads or on the sand piles themselves?
On the roads.
And what is your role with REI and the development of BB Draw Farms?
Let me object. That's a non-jurisdictional issue. That's not before this board, and it's frankly a waste of time to be discussing it.
It just shows conflict.
Again, there's
All right.
there's no decision that this board can make that is relevant to that question.
I don't know. Yes.
Like this one.
What's that?
Like
On slide 51.
staff presentations outline this.
Oh. Yeah. So it's already answered. Yeah.
So on the land lease that you have, Mr. Ager, for REI, is any of that 422 acres in dispute?
Again, same issue. Any land ownership issue is beyond the jurisdiction of this board. These are private matters that would be brought up in a court proceeding.
What I got?
This is now Wareham. I have a question that maybe is for staff, maybe is for the applicant, just because this is somewhat unique in a sense, going back again to the trigger here of selling the material, right? And again, I understand that that's not the only thing. If that didn't come up or something, what is the typical process? Who is the typical agency who oversees a simple dredging operation of a reservoir?
Well, I'll tell you from applicant's position, there is none. Under Colorado Constitution, you have the constitutional right to appropriate water. You have the constitutional right to condemn land for water infrastructure. There's nothing that prohibits you from recapturing sediment from a reservoir that's been filled in over time.
Right, these are developed resources that are privately held.
Yeah, it's a vested right.
Or a vested right.
Yes.
And you are maintaining the capacity of the reservoir.
Correct.
And in doing so, it ends up that you're dredging and creating stockpiles, which can look like mining, but in this sense, until you start selling it, is not mining.
I understand that's the board's
Sorry, I
position.
got to sit through the hard rock mining rewrite a couple years
Yeah.
ago, so you're gonna just have to listen to me.
I understand
Work out on
the
this.
board's legal position, or the division's legal position is that once it is being sold, even if it's not the primary purpose, that is the triggering
I'm
event.
just trying to kind of set the stage here a little bit for those that
Yeah.
don't get to sit in mining quite as
Yeah.
frequently. Now, that is my question, like, let's pretend there was no sale of materials.
Okay.
What is the conversation? What is the
Yeah.
where does this conversation happen, or does it happen?
Mr. Chair, if I can respond to that.
Please, sir.
It's a good question, and I'd say based on our experience in dealing with these reservoir issues, I would agree with council's statement that there really is nobody that's providing oversight on this.
Okay.
So there wouldn't need to be a conversation with our office in that scenario that you described.
And just to clarify, so you're aware too, to the extent that you have the regaining capacity piece and you have the enlargement piece.
Right.
The enlargement piece is, again, an appropriation of water that goes through the water court process. And FRICO, if necessary, has the constitutional ability to condemn land around it if
Right.
it were to make it wider, which it's not doing, it's just going deeper.
Yeah.
But
I
there,
understand
yeah.
that part, but I'm just trying to simplify it, just based on, I think that there's a ton of follow-up questions that this board could have based on previous conversations or other examples we've seen of mining operations that have gone outside their permit or something else, or we have had some fairly significant, whether it's penalties or something going on here, but in this sense, I'm just trying to make sure that we are understanding this in our purview correctly, that this is number one, a reservoir, number two, a dredging operation to regain capacity of the reservoir, and that the trigger point of why we are on this side of the field right now is the sale of what could be considered a commodity, even though that was not the initial.
So just to follow up on that, just to make it clear in my mind. So other than the part that was accidentally discharged to Lake Christina, which is under remediation right now, all of the spoils, all the stockpiles are on privately held land that are either controlled by FRICO or a company that is partly controlled by FRICO. And
Scott, you want to answer that?
Yes, that's correct.
so they have not discharged on other public lands or other private lands.
That's correct.
So I'm trying to be clear too. I do understand that we wouldn't be involved if it wasn't a sale of the material. So my question is, if you didn't sell the material, you just gave it away, we also wouldn't be involved, correct?
No,
So that was actually, that's why I was going to ask, is they didn't transport it.
Yeah.
I mean, the material's never been in a truck, right? It's never been used public highways or whatever for transport.
Scott, you want to answer that?
I can. It's Weld County's position that if it's being transported offsite on public roads, then we would need the mining permit.
Okay.
Yeah.
So it's the physical, it's not really it's not the money. Money's not the issue. It's what's happening is the issue.
Like it's
I think it's the reality that there's sand there and it's either going to stay there or it can be moved for some financial benefit.
I get it. So
Yeah.
whether it was sold or not sold, once it's moved out, it becomes a mining issue.
Mr. Chair, I'll just clarify on Mr. Baker's statement. A better way to describe it would probably be if a commodity is being introduced into the marketplace,
Okay.
whether that is sold or offered for in-kind services, we would still view that as one and the same.
I will just note for the record, and not to, just in case this gets appealed, your statutes are very vague about that issue. And I'm not 100% convinced a permit is needed for this operation, but we're here and we'll get the permit.
Any others? Anything else?
So back to the concern that I'm sorry, I forgot your name now. She had about a property transfer. That was another, under the previous thing was
Yes.
considered non-jurisdictional.
Yes.
That was. Do you have any other questions, man?
She's still, oh, there she is. Okay. All right.
All right, next, thank you, Mr. Edgar. I think that's all for today. Next witness that Franco is going to call is Lisa Shea, who's sitting next to me.
Good morning.
And can you please state your name and spell it for the record?
Yes, my name is Lisa Shea, Lisashea.
And where are you currently employed?
Ecological Resources Consultants.
And what is your current position there?
I'm a senior project manager.
And what's your educational background?
I have a BS in civil engineering.
And are you a licensed professional engineer?
I am since 1998 in the state of Colorado.
And how long have you been employed with the RC?
Since 2014.
And what type of engineering work do you do?
So a lot of the work that I do centers around water resources. I do hydraulic and hydrologic studies. I do water balances for mining industry, showing where water goes and surpluses and shortage that there might be. I do a lot of civil design work, so I'll put plans together that show grading plans, site layouts, reclamation plans, closure plans for mining I have done in the past. I also do a lot of regulatory compliance documents because FRICO does own these large reservoirs. They have jurisdiction under dam safety, so we make sure that those dams are safe, and so we report on those yearly in some cases and bi-yearly on other cases.
And where were you employed before ERC?
So I was, prior to ERC for about 22 years, I worked pretty much in the mining industry. I was a consultant. It was hard rock mining, but a lot of the principles are still similar as far as surface work goes in that I did a lot of design of embankments, ponds, roads, ditches, drainage systems, lining systems, collection systems, making sure things were contained and where they needed to go. And all that information was compiled into reports that were sent to governing agencies for the permitting process or for compliance requirements.
And how long have you been a consultant for FRECO?
Since 2014.
And what do you do for FRECO?
So for FRECO, again, I do hydraulic and hydrologic evaluations because their system is so large and they have a lot of different infrastructure, gates, reservoirs, channels. When we need to revise them, amend them, enlarge them, bring them into the 22nd century, I don't know what it is. We do all that, all the hydrologic and hydraulic evaluations associated with that. I have a lot of background also in geotechnical engineering. So I have done drilling, test pitting, all that kind of thing on behalf of FRECO to make sure that their dams are stable and if additional instrumentation is required. And I have reported that to dam safety also. Another big thing that I do for FRECO is review. There's a lot of third-party applicants that want to cross their canal or build a development right next to it. So I look at a lot of those reviews and make sure that they're conforming to FRECO's design review criteria and to make sure that those developments aren't adversely impacting FRECO.
You ever done any mining work for FRECO?
I've never done FRECO. I don't know that they have another mine.
If we can call this a mine. So this is the first instance where we've been in front of the RMS or you've been in front of the RMS for FRECO. And have you testified as an expert witness?
I have, yes, once before. It was related to a water project. And really, we were looking at structures on a system to make sure that they were adequately sized, that they were also old, and that they were in structurally stable condition.
All right, and have you assisted FRECO with the application that's pending before the board today?
Yes.
Oh, sorry, I have a technical issue. Give me a sec. There we go.
It's not displayed.
Are you displaying? Yeah. Technology, everybody's favorite friend. There you go.
Always happens. I have a backup just in case.
Tammy, help. Help.
There we go.
Okay, quickly.
All right.
What you have up on the screen right now is the mine application form that we put together, which is many, many pages long.
Great, and that's Exhibit 8. And was there an amendment or a revision to that?
Yes, so when we originally issued this in November, DRMS came back and said it was incomplete. There were a few items that we needed to address, which we did, and then we reissued that entire permit package back to them in December, early December, and then by December 16th, I believe we got the yes, your application is complete and we will now begin our review.
Great. And that's Exhibit 9, if I could get it up, but we'll just go ahead and skip that one. But for the record, Exhibit 9 was our amended application. Okay. Now, you're aware that there's been some issues that have been raised by objectors in this case.
Yes, I am.
And I'd like to just go through those one by one, and we can just kind of talk about how Franco's dealt with them. The first is concerns regarding water quality and pollution due to dredged sediment. Can you describe what that issue was?
Yes, so through the permit process, DRMS, and they've already spoke on this, provided adequacy letters to us. There was 3 of them, so we had to address each one of those independently as time progressed. In their first adequacy letter, they had requested that we chemically characterize the materials that had been stockpiled out there. So we went out and we collected, this was in February, we collected 6 samples, 2 from the north stockpile, which is called N1, 1 from the west stockpile, 1 from the in-res reservoirs, and 2 from stockpile number 1. And then later on, after we were addressing all of the objectors' comments, there were some comments regarding materials that may have gone into Lake Christina. So we subsequently went out there and took 4 samples, and that was in March 2025.
Hey, look at that, just in the nick of time.
And in addition, we did take water samples.
Okay, let me see if I can share that map with you so you can show. There it is. All right, now we're cooking again.
Yep.
Can you show the board where those samples were taken from?
With your help, yes.
Yeah.
If you can see, so in February, N11, N12, those were taken in addition to down south. We took W11, W12, 11, and 12.
And those were taken in February.
Those were taken in February.
All right, and then did you take additional samples in response to some objector concerns?
Yes, we did. And those are LC, if we go over to Lake Christina, we've got LC1, LC2, LC3, LC4, and LCE1, which is a natural basin out there within that northern stockpile area. So we took the LCE1 then.
Great, and what did you do with these samples?
We brought them to E-Analytics, it's a laboratory in Loveland, Colorado. And we had them tested for SVOCs, VOCs, RCRA8 metals, and with the procedure in accordance with DRMS, which is the SPLP procedure.
And I have on the screen Exhibit 17. Can you describe what that is?
So yeah, these are test reports from the lab. So if you go down and we can just look at an example. So this is just kind of the chain of custody, so forth. And then here we start getting the actual results of the analytes that were analyzed and tested for.
Great. And then were there also testing results for the ones done in March from Lake Christina? At the
Yes.
North Settling Basin?
Yes, we did the same type of testing.
Okay. And all of these third-party reports were provided to the RMS?
Yes.
And what was the results of the testing? What did it show?
So all of the materials, soils, and water collected in February from the stockpiles, they were either non-detect, meaning they were the method detection limit. They did not register a reading. There was one barium, I think it was, in the RCRA8 testing that showed a value, but it was way below the regulatory requirement. And then moving on to the Lake Christina. So Lake Christina and that north settling area, or that north basin, we did take samples there. Everything came back similar, with the exception of methylene chloride. Methylene chloride came up in 3 of those samples. That was above the Colorado regulatory statute for groundwater.
And do you understand that the RMS staff has an opinion in regards to the methylene chloride?
Yes.
And what is that?
So methylene chloride, is found, the oil and gas industry used to use it, a lot, used in paint thinners and things like that. In Frico's operation, we used none of those chemicals. The only kind of chemical that we would use is the fuel to fuel the dredge and the equipment and so forth. There's no other chemicals used on the project. So DRMS's standpoint was that this methylene chloride was not a result of the dredging operation.
And in your opinion, do you agree with that?
Yes, I do.
Well, what will FRICO do in the future to monitor these types of issues going forward?
Right.
It's granted.
Yes, so we will be taking samples monthly from the dredge, because that would be the point, not the dredge, the cyclone, because that would be the point of discharge. We will take samples from there and it will be tested for the VOCs, metals, total dissolved solids, and then quarterly we'll test for SVOCs.
Great. Let's switch gears here and talk about another concern of stormwater runoff into Milton. As part of FRICO's mining plan, how does FRICO intend to deal with that issue?
So we've come up with drainage plans, and we have a whole set of plans that show how stormwater is handled. And in most cases, it requires a swale or drainage berms that would catch the water that comes off of the side of the stockpiles, and that water is directed toward a sediment trap. In a lot of those cases, those sediment traps are designed so that they're long and thin so they can hold the 100-year storm event, so that water will infiltrate, and what doesn't infiltrate, it would go back into the reservoir.
All right, does FRICO have any permits for stormwater discharge?
Yes, they do. So prior to doing any kind of dredge operation in 2021, we reached out to, well, first of all, reached out to Weld County, who didn't require a permit. And then they said, but CDPHE, reach out to CDPHE. So we reached out to CDPHE, and they told me that we would need a stormwater discharge permit. So that's a COR 400,000 series permit. So at that time, the dredge operation was really just on the west side, and it only included the in-res ponds. So from the dredge, materials going into the in-res dredge ponds, and then they were allowed to dry out there, and then they were bringing them over to stockpile them in stockpile 1 and a little bit in the west stockpile. So that permit in 2021 included that area only. So as we progressed in time to the next year, 2022, we realized we needed the additional dewatering ability. So that's when those ponds, you'll see those settling ponds that are constructed on the northwest side of the reservoir. That's when we put in an additional application to account for those facilities. And then,
Sorry to interrupt.
Sorry.
Just real quick. You put in an additional application to CDPHE
and we did get a permit.
as part of your process for dredging the reservoir.
So they knew what we were doing because I
Right.
put the plans accompany
Right.
the permit application.
You weren't mining at that point. You were
No,
dredging a reservoir.
that's correct.
And you still, though, went through CDPHE, got
Yes.
appropriate permits,
Yes,
had someone check your stormwater, situation, had someone look at the
Right,
water monitoring, all of those elements.
yes. And
Just because prior there was a comment that there's no oversight whatsoever when you're doing a
Yeah.
process. I just want to reverse that a bit back and show that there are still agencies that do oversee, you are still in conversation
oh, yes,
with other state agencies.
yes,
Because obviously water's
Right.
moving around, things
Yeah.
are happening, you're
Absolutely.
creating something, right? You just weren't doing it in the context of a full mining
mine.
permit.
that is correct.
But you are still doing all of the work and the thinking that
Right.
falls into that.
Right.
Sorry
So,
to interrupt, but I just.
no worries. But then we did the same process when we moved a little bit further north, and then we
Right.
did another one, 2023, that moved to the north of this facility. So we have 3 permits. We have been in contact with CDPHE, and they want us to combine those, but we've been doing a lot of other things, so that one is, that is pending. We will do that.
So from a
But these
narrative
are-
perspective, I'm sorry.
Uh-huh.
From a narrative perspective, though, when we say that this has been ongoing since 2021, that is correct, but it's not without any one.
There was an
watching
overseer,
or talking
absolutely, yeah.
or
Mhm.
through interfacing with other state agencies. There was other state agencies involved that were not necessarily DRMS.
Correct.
Okay.
And just for the record, those 3 permits are exhibits 31, 32, 33. I'm scared the computer's gonna blow up. if I
Yes.
start switching.
Yes, they are.
And they're enforced, they're current.
They're
So-
current, yeah.
Yes.
I'm sorry.
Oh, no. I think we had to update them in 2024, all of them. There was an inspector that came out to site, in 2025, I think in March,
March of 2025.
March 2025. There were some corrective actions that we did have to, respond to them with and actually take action out on the site, which we did. And we responded back to them.
And the CDPHE at this point, are they requesting an additional permit for FRICO?
Yes, so Bill, you have to remind me when we did receive the letter, but we did receive a letter from the CDPHE that said, they have looked at the operation and they think that a sand and gravel COG 500,000 permit may be required. And that they required FRICO to put in an application within 30 days of that letter.
And did FRICO do so?
Yes, they did. Yes.
And can you look at exhibit 30 on the screen? Is that the submission to CDPHE for the new permit?
That is correct.
And that was just here on June 12th.
Yes.
And CDPHE hasn't acted on that yet.
I think we may have heard one question or comment from them.
All right.
Counselor, just want to let you know you got about 10 minutes.
Thanks. Okay, let's talk about the removal of Lake Christina from the mining plan. You heard Mr. Edgar's testimony that that's going to be
Yes.
Taken care of.
Yes.
And then let's go to our last topic here, the ecological concerns from the sand pile. Has FRICO submitted a reclamation plan
Yes.
for the sand piles?
Yes.
Can you just briefly describe that?
Yes, and it's, Chris has already, you saw the drawings where you have all those green blobs on the facilities. So what would happen is we're hoping that there won't be these big stockpiles, but if there are these big stockpiles, we would regrade those to a 3-to-1. A 3-to-1 is a good slope from stability perspective and for actually growing vegetation, because that's our primary focus, is to get those revegetated. And FRICO's going to be out there for a lot longer, so they're going to want that same thing, and they've got the water right there, so they're going to, and they do have the ability to revegetate, so they will monitor them, and anything that needs to be remediated, that will happen.
Great. All right, and the last question I have for you, and it's a weird question, but it's only for purposes of making sure our record is complete here. Are you familiar with the requirements of section 34-32.5-116 regarding reclamation plans?
Yes.
And in your opinion, does FRICO's reclamation plan meet the requirements of that statute?
Yes.
I don't have any further questions, but other people might.
So I just have one quick one. So the current reclamation plan that's in place, that we're considering or whatever, is in the would be the reclamation plan if the material was not to be sold.
That is correct.
And so and there's a finite volume because you're only increasing the reservoir a certain amount of size.
That's right.
Right. So this is like not an ongoing. It's not you don't get back to a corner for size or whatever. You're just basically taking it out and putting it in one
Yeah.
place, and the volumes and all of that.
Yeah.
And so this reclamation plan represents that.
Yes, the maximum condition.
Yes.
And we have only so much we can take out of the reservoir
Yes,
before the
right.
outlet structure does not work. So
Yes.
the outlet structure has to work.
Right. And that's a storage. You're increasing it for storage, so there's only a certain amount of storage. It's 34. It's to get to the 34,000 acre feet, right? Okay. All right.
However, over time, there's gonna be more fill in.
And guess what? FRICO is, they're very concerned about that also. So designs are in place for doing a sediment basin kind of upstream in their fill ditch. So to hopefully not have this happen again. So that is in place. And we started construction, but it got too far into the water season, so.
This is Kim Coleman. I have a couple questions.
Oh, sure.
How will Fricko guarantee that the fines and sediments will not escape into Lake Christina or Evans number 2, given the past visible flows
Good
from
question.
the historic?
Right. So what we've done at this point is up in that northern area where materials are coming off from the cyclone and water's coming into that north stockpile area, we now have constructed embankments around that area that are lined with geomembrane. And then we have outlet pipes that drain back into Milton Reservoir. So all water is going back into Milton Reservoir.
Great. And then one last question. I know you guys are all contractors of Fricko. Has Fricko committed to any third-party environmental oversight or just internal quality control?
Scott will be better at answering that question, but Fricko does have an environmental consultant that is separate than ERC and who they regularly use to do a lot of their environmental sampling and so forth.
I actually have a follow-up question for Mr. Edgar and Mr. Edgar, and completely fine because this is business and it's fine if you don't want to answer this question. But just in terms of selling the sand, is it only been this oil and gas neighbor that kind of was looking at it for remediation things, or did it expand beyond there once we found out there was a sand commodity there?
So our sales last year were just for reclamation projects. Once it was determined that we needed to get a mining permit, I started investigating what other options we would have for the material, and have come to learn that a fair bit of the material, if processed through a sand processing plant, could be used in the oil and gas industry for frac sand. The material that is too coarse for frac sand, after it runs through the plant, would be suitable for concrete sand or construction sand. And then the fines, the silts and the clays, we would be isolating that as well. And that could be sold as general fill.
So is that in a sense kind of like why you felt like it was economically reasonable to go down this path, aside from obviously compliance? But I just want to make sure that I'm sitting here in this seat and being responsible to you as business owner and to the state of Colorado, that we're not assessing something that, you know, it was a one-time deal and making a big thing of it, or if you're kind of feeling like, oh, hey, now that I'm looking at this perspective.
It's the latter. Now that we've gone this far down the path, I'm confident that there is a market for the material and it's economically viable.
Okay. And the end result, if you're successful in that, would be a final reclamation with very little stockpiles.
That's correct.
Anybody? Mr. Lopez,
All right, thank you. And we'll next call Tyler Worley. And we're going to skip a lot. We're going to hit the highlights. Can you state your name for the record?
Tyler, Tyler, Worley, Worley.
And where are you currently employed?
Ecological Resource Consultants.
And what do you do there?
I'm a senior ecologist.
And what's your educational background?
Bachelor of Science in Rangeland Ecology and Watershed Management from the University of Wyoming.
All right, and have you been participating in the application that's pending before the board today?
I have, yes.
And what did you do?
I oversaw the wildlife information report that was completed.
All right, and as part of this application, did the Colorado Division of Wildlife provide any comments? Application?
CPW did provide comments, ranging from mule deer, severe winter range habitat to migratory bird species.
And did you or ERC file a response to the concerns raised by CPW?
We did, yes.
And just very briefly, can you kind of talk about how you address those concerns?
The main concerns were the severe winter range habitat. CPW had recommended no construction between, I believe it was December 1st through April 30th.
And that's for mule deer, just so it's clear.
For mule deer, yes. And FRICO said they would accommodate that, no construction between that timeframe. The other concern was bald eagle nests. CPW had recommended a no surface occupancy between or year round for a quarter mile, as well as a half-mile protected buffer from December 1st through August 1st.
And does FRICO have a eagle take permit issued by the United States Fish and Wildlife Service?
So as part of that process, yes, FRICO applied through the U.S. Fish and Wildlife Service a eagle disturbance take permit, which generally allows enough disturbance of an activity that an eagle may or may not fly away. If it flies away, abandons the nest, that is covered under the disturbance take permit.
And Exhibit 19, which is shown on the screen, is that the current eagle permit?
Yes, that's the permit that was issued through U.S. Fish and Wildlife.
And that's valid until 2029?
Correct.
Any other issues that CPW raised regarding fencing?
CPW had recommended that if fencing was to be used on the project, that it comply with their recommendations, which is smooth top and bottom wires at a certain height that'll still allow continued passage for wildlife.
And noxious weeds and reseeding?
Recommended a noxious weed management plan prior to any construction activities, which we completed.
Okay, and any issues regarding to lighting from the?
If any lighting was to be used, CPW recommended down shielding those lighting and faced away from any wildlife habitat.
And did CPW raise any issues about the future sand plant?
Future sand plant, they were concerned about the proximity to the eagle nest and migratory birds. However, the sand plant is going to be located outside any of those protected buffers.
And those are the species activity mapping that you used to determine that?
Correct.
And did CPW, after seeing ERC's response, have any further comments?
CPW said they had no further comments. They were satisfied with what we provided.
Okay, and really quickly, Exhibit 22 shown on the screen, that's an email from CPW.
This is email from CPW from Lexi Hamage saying no further comments.
Great. I think we made it under the time limit. All right. No further questions for Mr. Worley unless anybody else does.
It's down to.
I have one quick question.
Yes.
Jim, go ahead and I'll follow you.
Okay, Bill. Regarding the Bald and Golden Eagle Protection Act, how does FRICO plan to monitor and report compliance?
So as part of the disturbance take permit that FRICO has, part of the terms and conditions in that is monthly monitoring. So ERC is under contract to do monthly monitoring, which we're doing currently. Following monitoring, we submit an annual report to U.S. Fish and Wildlife. And that monitoring is going on until 2029.
And that's currently going on now?
Now until 2029, yes.
Thank you.
My turn.
You're
Kim, are you done?
I am, Bill.
Okay. Yeah, okay. So if you go back to that permit, it was just up there, you showed the permit. First, you called it the Eagle Disturbance Permit.
Correct.
And I looked at that device or that instrument and it said 2024.
It was issued in 2024. It's valid through 2029.
Right. But we've also heard in this meeting here today that mining started in 2021.
Correct. So we initiated the consultation with U.S. Fish and Wildlife. Dealing with the federal government can take some time, and so that process from 2021 up to 2024, we were coordinating with U.S. Fish and Wildlife. By the time that permit was issued and signed off from the feds, it was 2024.
But my last question, in that time frame, was one of those eagle nests abandoned?
There are 4 eagle nests mapped through CPW. 2 of those nests are active. The other 2 are considered alternate nests to those other 2. There was a 5th eagle nest, and that was considered destroyed by CPW, and destroyed being it may have been abandoned. The nest is no longer there. That's not to say it's from any mining activities. That's just a natural process. The nest was abandoned over time. It just became disintegrated.
But I'll mention my point later. But there was 3 years of operation there.
Correct.
There was no legal permit. Correct.
Correct.
Anybody?
Thank you.
Just one last question on redirect here in regards to the last point. Within that 3-year time period, though, the process was happening to get a permit, correct?
Yes.
Can I follow up on that?
Sure.
So you did start reaching out to the Department of Wildlife back in 2021, or did you just start doing that in 2024?
CPW, I'm not aware of how CPW became involved in the project, but ultimately it was their recommendation to consult with U.S. Fish and Wildlife. So CPW is a recommending agency within the state of Colorado. They're not a regulatory authority. So in terms of eagles, that authority lies on U.S. Fish and Wildlife.
Okay, so let me rephrase. So when were you dealing with them to get this eagle permit prior to 2021 or to today? Did you start this in 2021?
Yes. We started consulting with CPW, who ultimately said consult with Fish and Wildlife. And through that process, we started that. Eventually, the permit was issued in 2024.
Thank you.
All right, we're all done.
You're done.
Thank you.
Very good. Thank you. Should we take a break? Yes, right. Yeah, should we take, do you have one? I mean, is this like a lunch break thing?
Yep.
All right, so we should be back. How long do we normally do that? 20 minutes, or should we be back at noon? Or is that not long enough?
That's,
Yeah,
well, do people here though need to go?
Yeah, and if you guys want to go and grab something to eat, there is a taco truck right out front. I have somebody posted downstairs so you guys can actually get out and be able to get back.
My comment is, some of us have a very important meeting this afternoon, so the shorter lunch break, the better for us.
Okay.
okay, should we? Let's do noon, yeah, all right, everybody, we need to adjourn till noon. How long break?
25 minutes.
Better get after it. No, I didn't have breakfast.
Yes, right. Yeah. Step more relaxed thrust, you know. So we don't.
get in these like, yeah, so like qualifying it for. Yeah, right. We just don't do that. Yes. But it wasn't. It's fine. Yeah, I mean, actually, it's just good. Right. And, you know, you usually get the same info. From there. Yeah. Yeah, right.
But now you know.
Right.
Oh, my gosh.
Very good. Great. Yeah. Hey, you show.
Right, yeah.
But don't kick me out. Anything else?
Good job. Thank you. I'll see you. We'll take with it. Thank you. Always has to. Yeah.
What time has it? Dude, okay. So, great, okay. Good.
Yes, so, there's no. Always. Yeah. That group. Sure. But it was. But you know, Arizona, New Mexico, Utah, Nevada, every state, there's, let me tell you. Right. Well, they pretty much. Yeah, and you know, I would rate them. They were. Yes, you step by the weekend. All right, guys. Got a scope of process and everything. Down there. So the process here. Yeah, we're by. But you know, it's still. All right.
Yeah, it's like.
Nice. Now, they talk about, you know, how we got.
So those nothing about this one? So what's the dice snare points?
Yeah.
Oh, this is just really.
Yeah, the guidance, right? It'll be actually great. Yeah, I'm not convinced. I heard it's heard.
I can see what.
I have to think. Yeah, I'm a pro. Well, it's a stuff to. Right. Yeah, it's really big. All kind of person. Yeah.
We've had lunch here for a while.
I really want to call it a site today, right? Yeah. Yeah, I'm gonna, so. Yeah,
And they come in here.
That's right.
It's beautiful, but
Yeah,
you're
just like.
supposed to actually start the sheet construction today. It's probably. Well, yeah. Yeah, so we'll probably go, it says January 8th, layouts.
Already Well, no, which one? Oh, sorry, sorry. Yeah. Sorry. Shot.
I was seeing.
My counterparts believe that.
Oh, really?
I know.
I usually ask.
But she's not so.
Well, hello.
All right.
Okay. All right, we can reconvene. So we're at the second half or after lunch portion of the July 16th Mineland Reclamation Board meeting. And we are partially the way through of all the presentations, and now it is the objectors.
All right, Bill, do you want me to go first?
Just don't take our 40 minutes.
I won't.
Oh, no.
I'll talk fast as usual.
Okay,
All right, should I go ahead and start?
yes, please, Ben.
All right, so my name is Kim Coleman, and I'm a resident of Beebe Draw Farms, directly impacted by the Milton Reservoir dredging operations. I come before you today not to oppose responsible water management, but to raise serious concerns on how this project has been handled, what it means for our community, our environment, and the integrity of the permitting process. Today, FRCO has openly admitted to selling dredged material for profit before obtaining required mining permit. While I appreciated they eventually submitted an application, no fines or enforcement actions were taken for this unpermitted commercial activity. This sets a dangerous precedent that operators can act first, permit later without consequences. We are not here to debate a future proposal. We are here because for over 2 years, FRCO, a nonprofit irrigation company, has been running an unpermitted commercial mining operation, extracting and selling sand for profit. This is a retroactive permit request to legalize operations that have already been underway. The notification process failed key stakeholders. Beebe Draw Farms Authority, which owns Lake Christina, a directly impacted water body, was not firmly included in the notification list because FRCO claims it's not a municipality. Regardless of the technical definitions, they are the landowner and they should have been formally notified. Metro District for Beebe Draw Farms, the Authority Board D1 and D2 are not a homeowners group. It is a Title 32 statutory special district, a political subdivision and quasi-municipal corporation under Colorado Revised Statute 32-1-103 per 20. As declared in this, the organization of special districts will serve public use and will provide health, safety, prosperity, security, and general welfare of the inhabitants of such districts. Under CRS 32-1-1001, D1 Board has the legal duty to manage, control, and supervise district affairs and to appoint employees to fulfill public responsibilities. FRCO never notified the D1 or any of the authority boards, despite clear requirements under Rule 6.4.16, Exhibit P, which is required to inform all municipalities and local governments within 2 miles. Some may argue D1 did not require notice because it's not a municipality, but that's an argument fails both legally and ethically. D1 is a statutory local government with authority over roads, drainage, and infrastructure, the very systems FRCO's operations impact. Ignoring D1 defeats the purpose of Title 32, which ensures all effective local governments are informed and able to protect its residents. Why the failure to notify matters, conflictive and abusive of rules. FRCO, under the leadership of Scott Ager, bypassed the only government within the legal right to review impacts, demand, mitigation, and represent residents. This is not a paperwork error. It's a systematic governance breakdown that raises serious concerns about the divided loyalties and public trust. I'm going to skip a couple of these because we talked about them already. Environmental harm has already occurred. In 2024, slurry and sediment-laden water flowed into Lake Christina. Only after residents raised alarms did FRCO change operations and agree to remove the sediment. This is reactive, not proactive. And it raises questions about how past damage will be measured and future harm prevented. Labeling commercial mining as a maintenance misled Wall County regulators, avoided triggering proper reviews, and concealed what was in reality a for-profit extraction operation. I don't know if you guys have my pictures of the sand blowing off the sand piles. I don't have a way to show them. Anyway, they should be in your packet.
Yes. They're in the board.
Oh, okay. If they weren't in, I can show them in a minute.
All right.
Okay. So dust and erosion controls have been inadequate. FERCO admitted that they watered the roads, but not the sand piles themselves. Meanwhile, residents have endured blowing dust and sand with little relief. So in their exhibit P, they said they're going to do sand suppression and mitigation, but they haven't been doing that during this past 2 or 3 years. We've been dealing with the blowing sand and dust. The board must weigh not just maintenance dredging, but the long-term impact of the planned reservoir expansion. The cumulative environmental footprint has not been fully addressed. Adding critically, the 422-acre land deal with FERCO relies on for stockpiling is under dispute. If this agreement is invalidated or found not to be a legal lease, FERCO may not have lawful use of the land they are depending on for this operation. How can a permit move forward when the underlying land access is uncertain? Finally, I want to stress FERCO has framed the permit as the only way to manage the growing stockpiles they created. The community should not have to be pressured into approving a permit just to solve a problem they caused. In closing, I respectfully ask the board to require full resolution of the land dispute, stronger environmental and dust mitigation, and a clear plan for addressing past harm before approving any permit. That's about all I have.
Thank you.
Thank you, Kim. I guess it's my turn.
Yes, sir.
There's only 2 of us. My name is Bill Caldwell. I live in the area of the subdivision up there that's within 2 miles of the property that's being mined. And I've got a little introduction here that I'll read to you. It's called Who's Caldwell. I'm a resident of the community for 12 years. I'm a professional engineer. I've been registered since 1980. I have registration in 5 states. A couple of those are retired, but I'm still active as a professional engineer in Colorado. I'm currently on 3 dispute boards with the Colorado Department of Transportation and their highway contractors. And I've been a engineer for a long time. First, I had 35 years in construction management, and now I've got 15 years with an engineering firm with Jenny Elsner. And we focus on broken things. And I'll tell you right now, I'm good at fixing bridges. I'm not good at judging water, but I'm good at fixing bridges. My mining experience is quite depth. Fresh out of college, we mined at the big taconite mines in Minnesota. We built a 5,000 acre lake out of 50,000 acres in Illinois. It's a nuclear power station. I've worked on 4 locks and dams up and down the Ohio River. And in order to build those dams, you have to do a lot of mining. And then last and not least, not too long ago, maybe 8-10 years ago, there was a large lawsuit in the International Tribunal, and it was held in Boulder, Colorado, but the mine for the San Cristobal Dam, San Cristobal mine in Bolivia, and that mine stands at 17,000 feet. So I was an expert witness there. I've been an expert witnesses in others, so I'm not ignorant of the situations that take on a board like this. I am a little weak on this particular project because some of our documents get impressed in time, and I'll leave that for one of my closing comments. So I've been around mines. What Franco's mining is minute to a lot of things we're doing. I have to tell you that I serve on the boards there in BB Draw. On the authority board, which manages the work and keeps the roads up. And I, as well as Edgar does too. And then I'm on the District 1 board. On the District 1 board, we collect the taxes. We are the homeowners. You heard Scott Edgar say that. We have over 158 homes. Each home's valued over $500,000. And with that, we bring in a pretty good wage. We bring in $350,000 a year, give or take, for the community to manage. We have swimming pool, we have maintenance buildings, we have tractors and wagons. So that's where I'm coming from. But today I'm speaking to you, not from that authority, and not as a district member. I'm speaking to you as Bill Caldwell, the resident who lives there and has seen what's been going on for the last few years. I didn't ask the board for permission to come here because I'm not representing the board, but I do have their interests in my mind. I've got four statements here to make. 4 different little they're not handouts, they're just my written notes. And I'll try to go through them very quickly. I learned today that I had some handouts to give you, but I didn't get them in time. I understood that when we got here this morning, people be exchanging things. And I didn't exchange my documents because they told me I couldn't. But I'm going to use this program here. You guys got this program from your people, and I can use it. If I can't, you tell me, but I can use it. All right. And let me ask, I got some pictures to draw up here. Where's Chris? Where did I get to my pictures here? He's got them on he's got them so we can draw them up.
You might want to sit here. This is where you can actually.
All right. Go there.
And we do that.
Okay, now where's the other pictures at?
You can't do them all at once.
I know I can't do them all at once, but can you minimize that one?
Yeah.
Just, okay, minimize it.
So they're all right here.
They're all right there.
Can take care of that.
I'm going to quote to you, take my verbiage from the different documents that have been presented to you. And then I'll make a short sentence about that, and then I'll tell you what my objection or my comment is on that. On October 20th, 2024, the Farmers Land and Mining Plan by ERC, we met those people. Page 6, paragraph 6.0 has haul roads in it, talks about haul roads. And they say, which is correct, the haul road extends the entire north-south length of the project. And now it's going to be 1.75 miles, 1.5 miles, on the west side of the reservoir, and it's approximately 20 feet wide, gravel based. And a good view of that would be your slides 5 and 6. And on slide 5, we're talking about a graveled surface road now, which extends the entire length of the project on the west side. Now, at the bottom of page 5, off to the left, it says, what's it say there? Mine access? Yeah, mine access. And it's a straight line. It goes up there 1 mile, because on the left side of that is the school district, what do they call it? The old school section. You get up there to the top and the mining property makes a left, to the right is the blue, and then you get over to Milton Reservoir. Now, that road, 20 feet wide and that length is a mile long, but it's not a mile and 3/4 long. The entire road is a mile and 3/4. Right there at that point where it turns to the left, the mining road that is current and used as a haul road makes a direct right, comes up and borders the fence line from the fence line that keeps you from driving into Lake Milton there, and it goes all the way up to BB Draw Parkway, and BB Draw Parkway is called out up there. And that's where it ends, because right there, it makes a right turn. This is a mining road now, and it goes over to the reservoir north section. For a given fact, the north 3/4 of that road, 3/4 mile of that road, you're gonna have to help me here, get this brought up, Carter. There we go. Did I get it up there?
No, I mean. Oh, this one?
That one right there.
Okay.
Now, I just close it, go to the next one.
No. There we go. Yeah, now it's visible.
This photograph was taken maybe 6 days ago, maybe a little bit longer than that. But right now, it's where their main haul road, they call it the haul road, turns off a BB Draw. A BB Draw is the east-west road, and then it turns to the south. And it goes there 1/2 mile, 3/4 mile. The document presented to you says that road is gravel-based and 20 feet wide for the entire length. Error. That's wrong. His top 1/2 mile is nothing but sand. And just 3 days ago, the wild turkeys were down there eating sand, walking down it. Error on ERC's part. Error on Franco's part. Now, Franco's going to tell you, oh, yeah, when we get our mining permit, we're going to put gravel on that. And then there won't be any dust. Well, right now, every morning, when Franco's foreman comes across that lake, or down from the lake on the north side, turns south on this road, I read somewhere in the documents, they're going to hold them to 20 mile an hour or something speed limit. That truck, I see it in the morning at 7 o'clock when I'm out on my tour with the construction, our maintenance people. Those trucks are going 40 mile an hour, and that dust is rolling out of the back of that pickup truck. My point made, this is wrong. There's not 3/4 of a mile of crushed stone there. There's a mile of it, but it's on the south end. I got another picture here if I can find it. All right, Chris, you better get back here. Do I go back to my folder?
Yeah, I guess so. Minimize that.
Minimize that.
Minimize that.
And I'm sorry about this, folks. I do a lot of PowerPoints, but can hit this one again.
Yeah, go over there.
Okay.
And then figure out what you want. And then.
This photograph,
Oh, they can't see it actually.
They can't see it?
No, this is not that good. Like one time. So
don't go away here. We'll get done faster if you don't go away.
yeah, apparently so. Yeah.
Right there, right. What's this document? This document is that same haul road in 2017. I was on the maintenance crew then, and what did we do? There's an eagle's nest right down the road from this. We'll show it to you in a little bit. And what do? We put this sign up and said, Eagle's Nest, keep off of. The only traffic used on that road from 17 until maybe 21 or when, and before 17, was the oil field people. You can see that. There's just two little tracks. And those oil field people were very respective of what's down the road a quarter mile. That's an Eagle's Nest. So when I seen them drive in the morning and talk to them, no dust, no noise, just a nice little meandering truck looking at his oil field stuff. So I'm telling you, your mining application is an error for 3/4 of a mile. With that, let's go back up here, kid. Give me some help. Go back to there.
Yeah, go back to there,
Okay,
go what you want.
all right. And
Actually, let's do this. Let's stop share, hit that red.
hit the stop share.
Yeah, right there. Back, and then go back over to the file. And then
You got what I want?
Mhm.
Okay. I think this is.
okay, now I want zoom actually. And this is going zoom down, go share, and then we'll share again. We'll just look out over here. We want this one
Right there.
share. Yeah.
Now, I didn't ask the wildlife fellow that was here a while ago, what nest number this is. They had the nest numbered 1 through 4, or 1 through 5. But I will tell you that this nest is very, very close to the mining operation that's on the east side of the ditch that fills Lake Milton. But now we're standing there close to the equipment, and we're looking at a picture of the Eagle's Nest. If you go on the other side of the ditch that feeds Lake Milton, is the road I showed you before. They call it their haul road. And from that haul road to this little Eagle's Nest is only 130 yards measured. And that 130 yards to this nest used to not be disturbed, but now it is. Because I asked the question of the person, and I know that Milton, Scott Edgar started mining in 2021. Until 2021, there was an eagle in that nest every year. So my point being, since 2021, he started mining, the eagle's not there. I can't control what the federal government says, but I can tell you that what I see and what I see out there is that road is not a paved road. It's not a haul road as per it's defined as 20 feet wide and structurally sound with crushed stone. So my first point is there. I would like for you to for you, and this might be a little hard, but go to page 8, slide it with the big red 8 on it. And right there on the north and it counters off to the west a little bit is that fill canal that fills the zone. All along that fill zone, all the way along that tributary that fills Lake Milton are countless avian nests. And there again, I'm preaching because I'm an avid person here. Those nests were much, much more inhabited prior to this mining operation. Enough said. I'll go on my merry way here. I'm trying to point out that we are losing our avian, we're losing our eagles. And yes, he does have a permit. He didn't get that permit till 2024. And by that time, a lot of those avians had moved out of there. I hope you see I'm kind of passionate here. Sludge at Lake Christina, we've seen a bunch of slides at sludge at Lake Christina. And I'm going to bring up this next fact because we the people, we saw and we've seen this. There was an agreement made between FRICO and the authority, and it said, okay, FRICO, you put a whole bunch of sludge in our Lake Christina. FRICO didn't deny it. They made out a contract. We have a contract with them that says you will take out the sludge of that got into Lake Milton, or excuse me, Lake Christina from Lake Milton through the Evans number 2 ditch. The Evans number 2 ditch collected the sludge and water. Some of the team up here tried to say it was more water than it was sludge. It was suspended solids and water. It looked darker than chocolate milk, and it was given to us for the whole year last year. Because we went into this agreement this year in March that they would take out the sludge. On the ERC, which is the document response to objections, on page 8, 3rd paragraph, 6th line, it explicitly states that there are a few inches of sludge in Lake Christina. I will bring up another page here. I believe I want 8379. This is a test pit just prior, and this is in March, early March. Prior to getting the sludge started removing well.
You're not sure.
I'm not showing it.
No.
All right, so. I took this picture along with some other pictures. That day they dug 8 or 10 tests, 6 or 7 test pits in the different areas of Lake Christina. And I measured the sludge in them. I have a notebook. I kept the depths and I took photographs. This is one of the better ones. If you look at that in the background behind the measuring stick, they went down to nice sand that had a sand bottom in it before. It has a sand bottom in it with 6 or 8 or 7 inches of sludge in it right now. In the ERC report, they explicitly state a few inches. Well, a few inches to me is 2 or 3. My ruler here shows at least 6 and maybe more. Also in the report, they said that at the bottom, you will find roots. And those roots will define that the sludge was there before FRICO started giving us sludge last year, polluting our lake. There's no roots in this. I looked at all 6 of those test areas. The only one that has roots in it, and I have to agree, is right up adjacent to the cattails or over by the park. We call it a park. It's the roadway that lets you down into the water there. There's a little park there. And now the big cottonwoods have roots there. Yeah, there's no roots there. So what I'm afraid of and what I'm objecting to is ERC's response to objections is the word, what's the word I'm using? They're quantifying. They're quantifying for FRICO that we only have a few inches of sludge. We have 6 inches of sludge. Some places we have 9 inches of sludge. And I do not want this committee, I respect the commissioners very much. I don't want your device is used as an instrument that goes back to my contract. I'm a civilian here. I'm a citizen who uses that lake on a weekly basis and sometimes daily. I don't want that to use to define against us when we start getting in an argument with FICO over how much he's going to lose. I'm going to state to you that on page 1, the agreement, paragraph 1, line 4, and this is a quote, FICO agrees to remove all such sediment to the bottom sand base of Lake Christina. Now, I can accept that, but I can't accept a report coming from your side of the fence, excuse me, you're neutral, coming from his side of the fence through you, using you as an instrument to tell me that I only have 2 inches of sludge. Okay, let's move pictures. That one, and then I go to share.
Yeah, yeah, so do stop share. The red. Yeah. And then do share again. Bottom, green. And then we'll just look for that picture, which is over there.
This picture here is across the Evans number 2 ditch. When FICO started mining last year and giving us what I call the chocolate milk, remember? It's worse than chocolate milk, it was more like a milkshake. They started giving us the water and the sludge, suspended solids, right into that ditch. That ditch flows down and comes into the north end, excuse me, the south slough there. We call it the south slough, and then we have the north end of the lake. There's a causeway between them with a 20-inch culvert. So as the bad water comes in, it goes through the cattails, gets settled out, and then comes into our fishing lake. With that, Evans number two comes into our ditch, and we have a walkway and a pathway and a roadway around our lake. But right here is the wooden bridge that goes across Evans number 2. And today, at this same time, the same sludge that was there when FICO got done mining last year is still there, because FICO came in with their big excavators and they excavated that whole Evans number 2 ditch out. And they took the muck out of it. Well, right there, this is one of my cohorts there, past resident of the neighborhood. We measured that sludge. That sludge underneath that bridge, it's still there because it hasn't been removed. That's 9 inches deep. Chris, come here and show me my 9-inch picture. Stop share. Right down here.
Just to give you a heads up, you got about 9 minutes.
I got 9 minutes. I'll hurry.
Right there.
All right.
Where do you go
There
there?
you go. So,
Nope, not yet.
not yet. You gotta share it.
I want to share.
All right.
Where's, oh, it's over here.
That's it right there.
So you did.
At 9 inches. That sludge is 9 inches deep. Now, ERC went on to say, and I'll try to hurry here. ERC went on to say that in the report, there was the top few inches had a different color to it. And I'm going to address that different color because when FICO filled this lake last year with their sludge and their water, they filled it much later than what Evans number 2 does. Normally, Evans number 2 stops the water in late August, and we get a bunch of red algae in there, and we have to treat it. This last year, no, they just kept giving us water. And normally in the wintertime, the lake gets dry, the slough gets dry, and you can walk across. About 4 years ago, we walked across that slough, and right up against the cattails were dozens. I don't have photos. I'm not lying to you. They had dozens of these egg nests where the carp and the bass and whatever, they fan their tails and then they lay their eggs in the sand. Those are dozens of them. When we get out there this year, in March and start walking around, and there's nothing there but sludge. So there used to be a very nice sand bottom there. There's not now. FRICO's report says that the top couple inches is a different color. It's a different color than the sludge below it. Well, perhaps since that water, all that was water and it froze all winter, perhaps that top 2 inches got dehydrated after it dried out and the water went away in the springtime. And then it was freeze thaw, freeze thaw, freeze thaw every night. Could that have changed the color? In my opinion, it did. You can ask ERC or you can ask FRICO did it. I'm sure they'll have their response. I'm trying to point out to you guys, excuse me, to the board here, we're not getting a fair shake, and I don't want this committee, or you, the commissioners, using a document as an instrument against me when it comes to the arguments between two people or two firms, FRICO's firm and our authority firm, our authority. I'm going to take you to your photo number 9, and that number 9 is the dredge. That's where that's a picture of the dredge. It doesn't have this. The cyclone's not operating right now, but the cyclone operates. And the water and the sludge fall out of it right there, and they make a big pile of it. The sludge came down to our lake. Every night when we walk there, and we have several people who walk there every night, they go by this operation. Right now, they do it. And in the last year, especially 2024, they would come to me and say, Bill, the sludge color coming out of that dredge is changing color. 1 week it'll be one color, and 1 week it'll be another, and 1 week it'll be another. So that tells me that there's more than one color of sludge that went into our Lake Milton, from Lake Milton into our Lake Christina. So saying that the top 2 inches is a different color, to me, that doesn't work. How many minutes I got, boss?
About 6.5.
Thank you. All right, Chris, we better change channels here.
Which one do you want?
I want these two. Yeah, can you put them up one at a time? Dust control on the existing stockpiles. This is the dust coming off the existing stockpiles. FRICO, Scott Edgar, he said during his meeting, he went and his comment was that right now we water the roadways. Well, this is coming off the piles. This don't just happen once a week or once a month. This happens anytime that wind blows. When that wind blows, it comes off that pile. We got houses 3/4 of a mile away from there. I was standing down there with one of them taking this picture. And then we have another photograph, same thing. I don't need to show it, waste of time. But this dust comes from the east to the west. In FRICO's engineering report, ECR, whatever, the haul roads and stockpiles will be completely controlled by water. That's on page 3 of the dust suppression from their 2025 January materials application. We don't see it. He's not doing it. I don't think the county has incorporated with him very well to make him put the dust suppression down there. Our people call the county and complain. They're not calling you. You're not controlling it yet. But we want that control. Now he's going to have 100 foot tall stockpiles all around this area, down at the north end, over down here. He's not going to be so tall, but he's going to have these stockpiles all over. They're going to all around his lake, and then they're going to be within 200 feet. He's going to have stockpiles that are going to have dust, particles, and dirt come on to what? they're gonna come into Lake Christina. He's already polluted it, and he's agreed to take out the sludge. Now he's gonna pollute it with dust. And why do I know he's gonna pollute it with dust? Right there, he's got dust and he's not controlling it. These piles are gonna be 100 some feet tall. He's gonna have to put sprinklers on them, which he hasn't done. But he says he will, all right? Elsewhere in the report for dust control, somewhere, ERC and all the documents, they said, and just keep in mind, the community is to the west. So with a western breeze, which we normally have western breezes, it's not gonna bother us. Or the homeowners won't have much problem with it. Baloney. We live out there in the flats, sand hills. Once a week, we get a windstorm from the east. It blows west. If you go down to the north end of the reservoir, where he's going to put these 3 stockpiles, 100 and some feet tall, 1 or 2 of them are really adjacent, very adjacent to the 200-foot buffer zone between his stockpile and our Lake Christina. Now, this is the Lake Christina, and I said this before, there's a walkway all the way around it. Every night, Rory Wardell and other people go down there just before dusk. They walk that 2-mile loop. So saying that because the wind blows from the west to the east is not going to affect us. What about these people with COPD and asthma that walk around the lake every night? Or when the wind's blowing, the dust is going to get them. We don't want that dust in our lake. You have the authority to stop that, and I'm not getting into which instruments used, which departments used, whatever. They say they're going to put water suppression on it. They haven't to date, and we deserve that. Me, the taxpayer, deserves that. And I got one last comment here. I would like to take you to, let's see what it is. In your documents, here it is. On your document 14, it says mining permit application chronology. It says here, March 7th, 2025, close of the public comment period. All right, we stopped. I didn't make any comments after that. Chris told me, hey, March 7th is it, get your last reports in, right? Then if I go to 15, the next one over, there's an adequacy review, Franco's second adequacy review, letter received. Franco's response to a third adequacy letter received. And this is all going up through June. You stopped us people. Right there it says, March 7th, close of the public comment period. But you let the applicant go on, and he makes his Franco's third response on June 4th. March, April, May, June. You didn't let us comment then. Where was the comment to us saying, hey, you have time to make comments. You can make more comments. We didn't get that. Okay, maybe it's a breakdown in communications, maybe it's a breakdown on my part. Maybe it was, but I don't see that, and your chronology don't show that. So you let, between your letters to Franco and his response, you let that go on a lot longer than you let us have our community response. Last thing saying is, Mrs. Coleman up there, she made a very, very emphatic statement that District 1 was not included. That's because we're a 39 or whatever we are, 32 and you're at 29. You have to tell people area 39 or whatever the statute is. Well,
Thank you very much, sir.
thank you.
All right,
Oh, time's time.
yes, time is up. Thank you, sir.
You're welcome.
Yep.
Sorry, I got the
Question?
passion.
Want to have a question?
Sir, we have
Sir,
some
we have
questions.
some
Did you
questions
hang
for
out
you.
for-
Oh, okay, I didn't.
It doesn't.
I thought you was telling me to get out my chair.
No. You want to go first, Jill? I've got
No, go ahead.
several.
Let me get just a sip of water, okay?
Oh,
My mouth-
here,
Yeah.
absolutely. I'm gonna jump around. I might just go from like the back, the last topic all the way backwards, just so it's all fresh. The adequacy, and this might be more for the division, you have party status, correct?
I, as a single person, made a complaint, yes.
You have
And
party
should.
status. You're listed as
Yeah.
a party.
Yes.
Okay, right.
Did party status have an opportunity to review the multiple revisions of the adequacy?
Yes, I can answer that. Michael Cunningham for the division. Yes, all of the documents that come in are publicly available. And so
Was anyone with party status noticed for the second and third revisions of?
they
the
were not,
adequacy?
and
They were not.
we don't notice them. That is not a part of our process. As was pointed out, there is a public comment period at the front end of the adequacy review. And once that is over, then yes, we have back and forth adequacy review with the applicant. But
But not with party status?
is,
Party status is different than public comment.
yes, party
This
status.
gentleman has party status.
Right.
So somebody could submit a comment to us at any time. For the purposes of establishing party status, that needs to come in during the public comment period. Following that, there is no prohibition on anybody sending us any materials. It's not going to change their party status and or anything at that point. They're already a party and they have the ability to review anything that comes in through that adequacy review.
So they just have to look up and find out that the adequacy review was in its third iteration going on through June. That would be on them to find that information out.
Yes.
And if I might, Russ means for the comment period is set by statute.
I understand the comment period. I'm asking about party status.
So that's something for Chuck to have to address and stuff more than me, so.
Yeah, so there are a couple trigger points for getting party status and then maintaining party status. So, and oftentimes it does start like a funnel, so you get quite a few people commenting. You have to show up at the pre-hearing conference to maintain party status, and you have to show up at the hearing to maintain party status. We started with 30 plus commenters. We had 7 at the pre-hearing conference, and we have 2 now. So, but yeah, I defer to the division and kind of staff's feedback on, whether or not folks who have gotten that initial party status get notice of the ongoing adequacy review.
Sounds like not. So, okay, sounds good. So did you live in BB Farms?
Yes, I do.
Did you get one of those notification
So-
letters?
I got a notification. I don't think it was an official mailing. I did not, my opinion, I didn't get an official mailing. I seen it and some of the neighbors heard about it, so they started. And then Scott Ager did say that he put on a like a little
hall.
presentation at our local. He said that, but that wasn't an official meeting, in my opinion, and it wasn't an official notice.
But it's tricky because I got 17 slides in front of me. And I can't find a map that shows me where the permit boundary is and where the BB Farms property line is. How far is that?
If I can explain the best I can, the BB draw right now, the houses
Yeah.
are 1 mile, between 3/4 of a mile and 1.5 miles due west of the mining.
Right.
Now, if you want the official property line, I don't have that.
But on slide 3, we've got a location and there's a red line and it shows what the proposed mining plan is. It's slide
Now-
8 or slide 3.
Is that on my property?
This is a Chris question. So on slide 8 and slide 3, you've kind of got some proposed mine plan slides. Here, okay? Then on slide 49, when we talk about how BB Draw Farms Authority doesn't need to have any specific notification, I can't tell like how far away the proposed mine permit is from this subdivision. Do you know that answer?
Not precisely, because all those REI LLC parcels have like a buffer between, in a sense, like the Baby Drop Farms and then the Franco parcels. It's over to it. That's the.
It's 200 feet. Does BB Draw Farms own Evans number 2 ditch?
No,
Does BB Draw Farms own Lake Christina?
yes,
How far is Lake Christina from the proposed
the property,
boundary?
I can't tell you because we've never had it physically surveyed and laid out. But the Evans number 2 ditch is to the west of the Lake Christina.
Yeah.
And then it flows into Lake Christina, so it's attached to Lake Christina. The mining application is for west of Evans number 2.
Yeah.
We did receive a request or a documentation that if we had structures within 200 feet of, if we had structures in that 200 feet area, and we do, we have that little bridge, we have some signage, and we have a little concrete outhouse down there, and I'm not sure the outhouse is involved, but the property of BB Draw Farms, Lake Christina, is within that 200 feet.
Okay.
My opinion. And
Go ahead.
Yeah, Jared Eager with the division. I went back and I did find the green return receipts for the notices that were sent to all owners of record with the 200 feet effect plan. The BB Draws Authority was included in that mailing, so they should have gotten a copy of the proposed public notice.
the authority got
It's up
that.
to 200 feet, and they were notified.
Thank you. But I'm relating to the homeowners within 2 miles. The homeowners within 2 miles, were they to be notified?
But yeah, the homeowners within 2 miles is essentially your municipal thing where you collect the taxes that then.
158 plus or minus
Because
1,000.
you just said you have to maintain the Evans ditch too for that red algae.
No, we maintained, the algae comes in Evans number 2 ditch, and we have to maintain it in Lake Christina.
You guys have to maintain it in Lake Christina.
If we wanna use it for recreation, we maintain it. So the Evans number 2 ditch gives us the water and we just play with it and catch fish out of it.
But you're not sure if it's within 200 feet.
Yeah, I'm almost certain it is, but I don't have
In
the
which
property
case you
line.
were noticed because he is saying that the authority was noticed.
There, he's saying the authority was noted. I'm saying the houses within 2 miles were not.
The houses pay into the authority and are what creates the authority.
Right. The houses pay into District 2, District 1 and 2 form the authority, but District 1 collects $350,000 in taxes,
To maintain all these.
and they're within the 2 miles.
For the record, I would just like to make a statement for the record on this line of questioning that the statute is explicit that it is only requiring notice within 2 miles of any municipality. And BB Draw Farms, Metro District number 1, Metro District number 2 for the authority. It's not a municipality is required under statute.
Under statute.
I knew that was gonna be an argument. No doubt.
Well, it's not so much that it's an argument, it's how do we coexist?
Right, how do we coexist? And I'm just asking you, if you don't do it on this one, look at it, because you're gonna have a lot of houses out there.
I have a question, and maybe, is Scott still on? I guess not.
Yeah.
Yes, I'm here.
Scott, my question to you is, we're dredging the lake to maximize the permit, capacity permit, correct?
Yes.
Okay. What's your time frame on that?
So.
In other words, is it gonna be completed? Will you be maxed out in a year, 3 years, 5 years? How long will this dredging process take?
Good question. It's largely going to be market driven. So the capacity of what we could remove from the lake at our current production rate, that's how we got to a 20-year mine permit application. However, dredging is not a cheap venture. And if the material, if we're not able to sell the material, say 5 years from now, I think we'd start looking at, have we reclaimed enough or enlarged enough space to not continue to fund the project? So I don't have a firm answer for you, other than it's going to be market driven in the longer term.
Oh, okay. So Bill, if I could.
Yes.
If I could. And I live on a quarry, and I suffer with dust and the same thing that you're talking about. But if I could for a moment here. If we did not grant this permit, they will continue to dredge. And the material will just pile up and pile up and pile up. So I don't see that as a solution. The solution I see is what Scott alluded to there, is some kind of a venture where we can sell the material, but in any case where we can move the material out. Because that dust is going to be there as long as you have piles. Now, they have great access to water. So yes, they could be watering it down. Maybe they can do a better job of it. But the point is, if it wasn't there, everybody wins. You win and the company wins.
I see your point, and that's a good discussion. Lake Milton is huge. Okay, it's 1,000 acres or something right down there. Okay, that 1,000 acres, he's piling all the dirt on the west side, and on the west side is all the houses are. If he wanted to be a good neighbor, why don't he pile it on the east side? And then when the wind blows from the east to the west, it'll go right back in his lake.
Well, and I, in all due respect, I think that's a conversation you could have with Scott. He seems to be a fairly logical young man. And I think that's a valid conversation to have. Because it's important to these people that they have a good relationship with their neighbors.
So the dredging is still actively happening right now?
It
Sand
is-
piles are getting bigger? Sand piles are getting bigger right now?
Yes, ma'am.
It's active.
I think, go ahead.
Well, I have a question in the sense of this timeline, and I'm sorry, it gets a little muddled between asking Scott the question and asking this. In other instances, if we were saying is something out of whack with the mine permit or needing some things, we would cease and desist, which also means you do not create stockpiles while you are under review here. If we're purely dredging, and that's really all we're doing, okay, fine, you're not in front of this board. Right now, yes, he stopped selling this commodity, but he's essentially stockpiling if there's active activity going on. And
That's not in our.
It is in ours. If this was, something, if this was a gravel pit and it wasn't a lake. And we found out that three brothers had a piece of land and they were just digging gravel and they didn't know they needed a permit. And we said, hey, you guys can't sell that gravel anymore, but they kept stockpiling the gravel. We would say, you can't do that. It's a cease and desist until you have an active mine permit, right?
But that isn't what Michael covered was what happened is once they started selling it, then it became a mining situation.
But if you know.
So the answer, I think part of the partial answer to your question is what came up before about other authorities. So the stormwater permit and grading permit from county and all these other things prevent stock. I mean, that's what they do. Like, I don't know what it is in Will County, but most counties is 300 yards or something. I mean, there's a limit that you can move without having to trigger a grading permit. Then you have to get a grading permit. You have to get a stockpiling permit. So I guess the question is they can't just keep stockpiling from the dredging without getting a grading permit from the county.
But they do have a permit to dredge. That's established. That's established. They have a permit to dredge, and dredging means pulling things out and putting it somewhere.
Who's
Am I right?
Who's the permit for dredging from?
Right. It's not a permit. They have a water court decree.
Decree to enlarge the, right.
And they have a constitutional right to obtain land for their water rights, and they own the land, and the ability to recoup that lost land is a constitutional right for them to exercise their water right. There's no statute that can prevent that.
Yeah, this is a.
I know this is out on the plains, but why don't we get the Forest Service involved? Just so everything is literally involved.
And I do understand, that Weld County requires a grading permit, but they have an exception in their code for cleaning out lake.
Well, and
Really?
And in all fairness, we do try to stay away from what's the county, what's the wildlife, and what's the water, but we try to stay away from that. We're chartered with mining, not other issues. But again, I go back to my point, Bill. The sooner they can accomplish what they need to do, which is to expand their capacity of that lake, the better off everyone will be, both the company and the residents and the whole area.
So
I'm speaking for myself, but some of the residents have that feeling. Now, we're like any municipality, 30% of the people care, 30% of the people are interested, and 30% of the people are only worried about taking their kids to basketball practice, right?
Well, sure.
Yeah, so that's who we are. Now, I'm gonna make one more comment, and if I'm out of line, just tell me and I'll shut up. Throughout this day and this ordeal, and throughout the documents I've read, there was a application to Weld County for a permit of something, okay? I don't know what that exact is, but in places, it says that permit is in place, and in other places, and I think I heard this from the applicant, that application is not totally approved at this time. That's my question, and you don't have to answer it. You can ask it, and maybe I'm out of time and I can't present that question. But where's the mining permit from the county, and what is it called?
Thank you very much. So I think what we'll do here is let's keep moving through the process here so that everybody gets, so we have the formal option here, and then there's some more time for discussion. Yes, sir.
I would like the opportunity to cross-examine Mr. Caldwell really quickly on a couple questions, which I believe is allowed under your rules.
Oh,
Yeah, time will
yes,
come out of your
yours.
rebuttal.
Go ahead.
It's very quick.
Okay.
I'm sitting next to you.
I don't buy it.
Same doctor. Now, Mr. Caldwell, isn't it true that you're the president of the BB Dog Farms Authority?
Yes, sir. I'm not here at any capacity of that.
I understand that. Is it my understanding that FRICO and BB Drug Farms Authority entered into the contract on March 7th, 2025 regarding the dredging of Lake Christina?
They did.
Yes. And you are the one who signed that contract?
I did.
So with your concerns that FRICO may not do what it says it's going to do in the contract, you have a remedy at law if you wanted to sue FRICO for a breach of contract, correct?
I believe I do.
Okay, all right.
I believe they do, right? I don't act without the authority.
Correct. And BB Draw Farms Authority does not own the Evans number 2 ditch. I thought I heard you say correct.
They do not.
Right. And so there's, and the picture that you had showed, you had some concerns about sludge in the Evans number 2 ditch, correct?
Right. Can I
And so,
expound on that?
so if PVIC has issues with sludge, FRICO can deal with PVIC about that?
I'd like to comment on that. The only reason the sludge is in Evans number 2 ditch is because FRICO put it there. When they put it underneath the bridge and then take it out, it's still there. I have no trouble with Evans number 2 ditch, but the water only goes one place. The water coming in Evans number 2 ditch can only go into Lake Christina. It cannot go to below Lake. It can't go any place until it goes through Lake Christina. That puts the sludge FRICO put in the Evans number 2 ditch into my lake.
Understood. And then you have a contract that deals with that with FRICO.
Right.
Okay.
And I'll,
Thank you.
Okay, thank you. All right. So the division? Yeah,
can I go sit down?
yes, sir.
Thank you.
Thank you very much, sir.
Yeah, I think a lot of the topics that we were gonna pretty much hit in our rebuttal were discussed during last round of discussion. So, really at this point, we would just open it up to the board if you have any additional questions to us based on what was presented.
I do.
Right. So,
May I?
mhm.
The oh, Mike, I hard to list. Mr. Caldwell mentioned the concern that about a lot around Lake Christina, the sludge there. So we understand that the applicant has a agreement to remedy that and take it out. In this permit application, the applicant has included the ability to put that sludge from that lake into their stockpiles and do that. Is there a quantifiable limit of, is it 2 inches? Is it 9 inches? Is what they need to do to clean out that lake, or?
It's kind of open-ended. It's how much they need to remove from the lake itself.
So we're not causing any restrictions on that cleanup activity of the applicants.
No, where they've designated 2 areas where they can place that material. If they were to need some additional area, it's still kind of within their affected area footprint. We would just ask them to kind of revise, that plan to include if additional space is needed, essentially.
Okay, so the application in that matter actually serves as a conduit to get that work done.
Yes.
Okay. Another concern that both Ms. Coleman and Mr. Colwell had is the dust on the roads and the stockpiles. And on slide 45, your slide 45, you indicate that they'll be revegetated after the material is being placed. They'll use binders. I'm going bottom up. Sorry, they'll use water trucks for dust suppression. Biodegradable water resistant soil binder will be added to the stockpiles to control. And then they'll be vegetated afterwards, and they'll be monitored monthly, which with Colorado wind seems a little weak, but offsite dust control is really not a jurisdictional issue, but yet how they maintain their stockpiles is a mining practices within ours, right? Correct. So getting this application will actually give some meat to the bone for them to actually put the binders on, put a water system and all this other stuff. But right now we can't tell them to do it because they're not under a permit. Correct.
And and if we conduct inspections, we can enforce that. If it's evident that it's not being done, then we can say that as a problem, to the applicant.
My my one comment to the division is monitoring monthly with Colorado wind season is probably not adequate. But be that as it may.
Their exhibit M has, they have, they're submitting an application, with CDPHE air quality. So, and all we require for exhibit M is just that, for a lot of these permits, we don't need to have them finalized. We just need to know that they're working with them, that they've submitted applications. So we can't, further, elucidate, or discuss that. So.
Okay. How does it work when division doesn't have enforcement authority until there's a permit? Is that correct?
Enforcement of the permit conditions, correct. We can't pursue enforcement action for mining without a permit prior to obviously a permit being issued.
Okay. So there's a lot of sins of the past, and all we can do is remedy by going forward, or not sins, but just things that could have been done a bit sooner and more proactive. So we're moving forward, which is a question at hand. Thank you. That's all I have.
One question on the notification. Within state statute, municipality must be notified. That's the municipality, not the homes within the municipality. Is that correct? Or how is that handled?
That's correct. That's correct. We would not then extend out those notifications to all of the homes within a municipality that fell within 2 miles. It would be strictly to the municipality itself.
So by notifying the district, I mean that there's actually some simulation there, some similarities.
I would say so.
Yep, thanks.
Okay. Any other questions? Other information? The division?
Talking about like the adequacy review process and how that, really, obviously the bulk of it took place, or, some of it, after that public comment period closed, but, had many phone calls, many emails with several of the objectors, obviously, certainly the two that are here today, regarding the adequacy review process, happily discussed with them and anyone, and very much encouraged to, gave them links and, and sent them PDFs for here's their response, very, kind of going over and beyond what is normal for a lot of these applications with objections. So really felt like, I tried to help make sure that BB John Farms and its residents were aware, and how FRICO has been addressing their adequacy or their application deficiencies going forward.
Mr. Chair, real quick, just out of curiosity, so out of the 33 objectors, how many withdrew their objection versus they couldn't make a meeting and deadline and fell out that way?
There was
There was just one that actually withdrew.
Yeah, she wasn't going to be able to attend this board hearing, but would have been able to attend the pre-hearing conference. But I guess our rules, kind of specifically, she would have had to would have needed to have a lawyer present for the actual board hearing. So, and then she decided not to go forward. And there were, a couple of other objectors that were present at the pre-hearing conference and maintained their party status. They're not here today. So.
And also in the pre-hearing conference, there is a process for proxy, so that if somebody couldn't make that specific meeting, they could do that proxy. And in this case and stuff, we actually did have a proxy and stuff for the pre-hearing conference.
Thank you, gentlemen. Try and get through this so we do it exactly the way the hearing order says. We are at the rebuttal statement for the objectors. If you'd like another few minutes, or if you.
Yes, sir. The only comment I have, and I appreciate your questions. You asked how many objectors removed their objection and how many didn't show up. It's very burdensome. Your process, being during a workday like this, is very burdensome to a lot of people, and also it's intimidating to just the general public. So, just my comment. You're burdensome and
Thank you.
And this is Kim.
Yes,
I have a comment, and thanks for listening to us. And this isn't my area of expertise, so bear with me. But I understand that we're moving forward now and looking at compliance going forward. But how is the board accounting for the fact that FRCO should have been more proactive from the start? This is their life, it's water. So they should have known what to look for, what to ask for, and been more proactive. Without proactive compliance, this community has already borne the environmental and quality of life impacts without proper notice or safeguards. How will the board ensure that the past harm is not ignored in the rush to permit future operations?
Yes, thank you very much.
May I just respond to that, Mr. Chair? Ms. Coleman, I appreciate that, the question. I think now that this comes under a permit with DRMS and staff, please correct me if I'm wrong. You've got a phone number to call if there are concerns about the operations working outside of their permit. Obviously, we will have some inspections in communications going on, but you have a place to call and you can notify the DRMS staff when you have some concerns, and we will be responsive.
And I appreciate that. Thank you.
Yeah, Russ Mays for the division. I'd also like to point out that on our website, we actually have a complaint form and stuff that gets, if somebody has an issue, we can't be out there 24/7, but the neighbors and stuff are. If there's an issue and stuff, when they file those complaints and stuff, they come directly to us and they're assigned to a specialist, and we get on it as soon as we can. So along with a phone call or an email, there's also another formal process and stuff for complaints and stuff. So there's a couple of avenues and stuff for us to react and stuff for any operation and stuff. So that's the most important.
And I would just add for the operator, I think the best practices that we have seen, neighbors have phone numbers of the contractors or the staff or the managers of operations, and that should be perhaps a first call to see if there's something that you all can do as good neighbors. So I'll add that.
Ms. Coleman, I think one other point that comes to mind is this is a first incident with this group, and they've been very respondent in getting a lot of information to the department in a timely manner. And should this happen again at another one of their facilities or another time, I'm guessing that the department would not be so lenient in working with them, that there would be different, first time shame on me, second time shame on you, right? So I do think that, they're very educated and responding, and I see that as a good sign. Now, how do we get the message out to all the other of their competitors or the other water districts, right? So good question though.
Thank you.
Other complication for communication is we only have so much authority, and CDPHE is also very important. And I would want to contact county officials also, because they have other authority. So it's not just us.
Very good. All right, so everybody, should we go on to the last rebuttal statement applicant?
Thank you. I'll be brief. I'm just going to call up Ms. Shea and Mr. Edgar really quick for a couple questions, clarifying questions. All right, now Ms. Shea, there was a lot of discussion and photos about the dust blowing off the sand piles. Can you inform the board about other permits that FRCO must get
Yes,
to
sure.
deal with those issues?
Yes, so we understand that dust can be an issue, and so about a year ago, right now, we have been in conversations with I have to always get these acronyms right, Air Pollution Control Division. And so we have actually been going through the APEN process, which you probably know, Air Pollution Emissions Notice. So the APEN process doesn't happen overnight, and it has been in the works for a year now. And there's different APENs for different aspects of the project. So for example, the mining itself, so the stockpiles, the movement of trucks around and that kind of thing. We have put together all that technical information. We have submitted that to CDPHE to begin with. they did some evaluation and came back to us and said, we need you to do this other study. So we are now doing this other study to see what the dust emissions would actually be. And what that APAN process, what I'm seeing it does is it kind of guides you through quantifying what the dust emissions could possibly be, and does it require a permit? And it does look like we will need a permit, and that would be through the Air Pollution Control Division. So we would get that other permit, but that process is very lengthy. And even though we don't have that permit, we are still liable to control the dust on the project site. And so that we know that, and we do need to take measures to do that. But we expect to have these studies done, I'm hoping this year, but then that's only one part of the process. Once those studies are done, those studies go to, I think there's 2 people at Air Quality that look at this, and they have a backload of different projects that are requesting this also. So they have told us that that is a 6-month process. Once all that documentation gets to them. But in the meantime, we still have to control, the air quality is important.
And is it your understanding that the CDPHE, the Air Quality Control Division, is the state agency that has jurisdiction over that issue?
Absolutely.
Okay. That's all I got.
Very good for me.
You have a question about that? Are you going through that process because you're in the midst of this mining permit, or are you going through that process because you're expanding and dredging or cleaning out the lake?
I really can't answer that. We're doing it because it was requested, I think, of us at some point in time.
Lisa, I can speak to that if that's okay.
Sure.
We were contacted by Weld County with complaints over the dust, and Weld County referred it to CDPH&E. And CDPH&E has said that we need to get the APIN. So regardless of the mining permit, we're still going through the air quality permit.
Okay, good. That's helpful. I'm just trying to educate myself on some of this because I feel like this may not be the last time we have this kind of conversation, and we're learning lots about reservoirs and dredging today too.
Yes, we have.
Yeah.
One last question. What's the status of the USR permit that is going to be submitted to Weldon County for this
Okay.
project?
Yeah, so use by special review. So in tandem with this mining application, we have been working on this USR. We can't issue the USR because one of the exhibits needs to be the decision letter from DRMS on, yes, they have approved the area for a mining to happen. So if you think the mining package is big, USR package is that plus 1,000 more pages. They are very complete with everything that we need to provide to them. We have it ready to send. We just need to finalize that one exhibit.
And is there a public process for that as well?
Yes, there is. And that one, I can't tell you exactly what the regulations are, but they are definitely, and we did have a sit down in November with the county. So they went over everything that they needed in their package. And it's the planning level, it's environmental things, it's development, it has a mining section too. So there's all that.
And how does that being communicated to the neighbors?
I have not,
They have notice for use by special review. They have notice requirements, I'm sure.
they will once we submit it.
Yes, right. I mean, they're probably similar. They'll probably have a distance requirement and the GIS search.
And we did reach out to Weld County at the beginning of all this, so just so that is there, and did get we did not have to pursue a permit because of the work that you can do to clean out your reservoirs.
Got it. All right, thank you. All right, Mr. Edgar, I just have a couple quick questions for you here really quick. there was some discussion about the road that didn't have any gravel on it. Could you explain to the board what is the plan for that road?
So my understanding is, as part of our application, we said that we would gravel that road or use dust control measures. And so once we receive the mining permit, assuming that's how the board votes on that, then we will take those preventative measures.
Thank you. Really quickly on back to the notice issue, which I want to make sure we're clear on the record here. Is Lake Christina within 200 feet of the mining area?
Yes.
And BB Drop Farms Authority owns Lake Christina?
Yes.
And you heard from DRMS staff that notice was provided as required by statute to BB Drop Farms Authority?
I did, and I agree with him.
All right, no further questions. Thank you, Mr. Edger.
You're welcome.
All right. Well, it seems redundant, but to make sure we follow the plan here, Division gets an opportunity for a closing statement.
Yeah, obviously you've heard a lot of testimony today. We appreciate everyone's comments. You know, we received this application. Chris and I both looked at this in detail. The adequacy review was quite robust for a construction materials operation. We asked for a lot of information given the size and scope and the objections received. We are confident that the applicant has addressed all of our adequacy review issues and that we could recommend approval of that application. That's our closing statement.
Very good. Mr. Campbell or Ms. Coleman, would you like to make another final
I'm fine.
closing statement? You're okay? Ms. Coleman?
I'm fine, thank you.
Okay, very good. That was fast. You're already back in the seat, man. All right. Good luck.
I won't be much longer, I promise. Well, first and foremost, thank you for the opportunity to present the application here. We appreciate the board's consideration. This is a unique situation. Something you guys probably don't see every day is, you know, this is a ditch and reservoir company just trying to, you know, dredge out its reservoir. It's not a mining company. That's not the primary purpose of project. The sand just happens to be a byproduct of that operation, and it's something that Trico has to deal with, and this is the best way forward, it appears, to deal with the sand. The evidence at the hearing that we put on just now shows that Trico has complied with all the requirements of Title 34 and the division's rules. All the evidence that we've put in front of the board today shows that Trico's addressed all of the issues that has been raised by the objectors. The wildlife impacts that were raised, Colorado Division of Wildlife has been satisfied with Trico's responses. Water quality and pollution from the dredge sediment, that sediment has been tested and it was within the regulations of CDPHE. Discharges into Lake Christina, Trico's changed its operations, has an agreement now to remove any of that sediment. The issue of mining without a permit, you know, Trico didn't understand or was not aware of the requirements to get that permit. Once that was made known to them, they immediately stopped their operations and filed their application, and here we are today. As far as ecological impacts raised by the objectors, Trico has a remediation plan. That remediation plan has complies with all the statutory requirements, and there's been no evidence that it does not comply with the statutory requirements. And again, with the notification issues, Trico complied with all of the statutory requirements. Only landowners within 200 feet have to be notified. Trico did so. The BB Draw Farms neighborhood is not a municipality as required by statute, and thus that's why notice to every individual landowner was not necessary under statute for that notification process. I would point to the board that under 34-32.5-115.4, the statute states that the board or office shall not deny a permit except on one or more of the following grounds. And I'll go through those really quick to show that we have complied with all of those requirements. That the application is incomplete and the performance and financial warranties have not been provided. DRMS staff has indicated that the application is complete. FRICO is willing and able to perform financial warranties that are required of it. The applicant has not paid the required fee. We have paid all of the required fees necessary for the application. The third grounds for denial is any part of the proposed mining operation, the reclamation program, or the proposed future use is contrary to the laws or regulations of this article. There is nothing that has been pointed out where FRICO is in violation of any laws or regulations of Title 34. The fourth grounds for denial would be that the operation is contrary to the laws or regulations of this state or the United States. There's been no evidence that FRICO is in violation of any state or federal laws. The fifth grounds for denial is whether the mining operation will adversely affect the stability of any significant, valuable, and permanent man-made structures located within 200 feet of the affected land. There's been no evidence that FRICO's operations will adversely affect any stability of those kinds of structures. The sixth grounds for denial is if the mining operation is located upon lands in a national park system, a recreational facility, a park and recreation district, or a state park recreation area. And you heard testimony that those lands are not located within any of those types of lands. And the last ground for denial under statute is that the proposed reclamation plan does not conform to the requirements of 34-32.5-116. There's been no evidence that FRICO's reclamation plan does not conform to those requirements. Ms. Shea testified that in her experience and opinion, the reclamation plan does conform to the requirements of that statute. So in conclusion, again, we appreciate the board's time. FRICO believes it has satisfied all of the conditions necessary for the issuance of the permit, and we request that the board grant the permit. And I'm happy to answer any final questions.
Thank you, sir.
Thank you.
Yes. Do I need to say something formally to close the testimony? I just did. The testimony's closed. All right. I don't think it's as simple as just asking for a motion, but what sort of discussion is all in your minds about things that are unclear? Or I guess I have one. I guess I'd start by saying I think I try to look at that outcome in the long run and then figure out how you might get there. I'm not sure it's exactly clear, but it sounds like because the real point of it is water storage, that there's two ultimate final outcomes. One is they're going to dredge and sell material, and you end up with some sort of reclaimed thing at the original grade of the site, which, you know, may be preferable. Or they're going to dredge and stockpile all that material and then, you know, revegetate it or reclaim it or whatever, and you ended up with however many cubic yards of mounds you have out there that are theoretically reclaimed now grassy hillsides or whatever. I mean, one way or the other, they are, because they're working on their own private property, right? If they don't sell the material, they are allowed to dredge their reservoir to make room for more water. So I guess this is a little bit about what Mr. Baker sort of was alluding to, which is in the long-term thinking of how this might work out for dust control and visual, the look of it, and kind of having the original grade, the the actual maybe better answer is to allow them to sell the material so that the whole site is probably closer to the original condition. I don't know if that's true or not, but I mean, if anybody else disagrees with what the two potential things that could happen are, those are the two potential things that I see happening. And so, you know, we really appreciate all of the testimony and all of the information, but ultimately, you're gonna have mounds or you're not gonna have mounds. And, you know, that's sort of what we need to decide, I guess, as a board, maybe what the better option is.
I appreciate that perspective because you're looking at the difference between the 34 million gallons of they or whatever it is, acre feet of storage that they want. You know, we're talking about 20 million yards of stockpile materials on that site. That's a lot of material.
Yeah, it's huge.
It's mind-boggling to me to think that would all be on that site.
Yeah. It's like landfill sites.
Yeah.
I mean, I think in addition to that, I think a lot of what's been the concern with this is sort of who's responsible for what, who's overseeing something, who gets to say what a stockpile is or whatever. In this sense, I know it might sound counterintuitive, but I almost think that it's an easier situation if it is within a mine permit.
Right.
Because you then have clear lines of, yes, what we're looking at here, and what I think the state of Colorado does an amazing job at is you're gonna have this activity happening no matter what. But what will this be in the future? And we're looking at what will happen in the future, not just right now. But concurrently, if we have an affected land permit as outlined on slide 5, your staff is going to be monitoring that, understanding what that is, making sure that those things are done safely, making sure that every single one of these things that does kind of not really fit in one box at the moment, that has all of these different jurisdictions within the state, still has to kind of all work together during the life of this operation. And so in that sense, I think that not only does it give us a clearer path to what things look like in the future, it gives the community, the neighbors, anyone else a clearer path to what things look like now while it's happening, because it's got a bit of a bow on it.
I would just say, and I agree with everything that's been said here by the board. I think that this is also, let's be honest, this is one of those unique situations, very unique situations where there's, you know, there's a gray line in some respects, depending on how you're looking at this and where you walk this. So I appreciate the residents, the neighbors, and the operator, you know, taking time, being engaged and going through the process with the team, and appreciate the DRMS staff as usual for your professionalism and work on sorting this out. But I just have to recognize that this is very unique to what we normally see. It's interesting though, the comments about, you know, overall, if you're thinking about dredging, this process makes a lot of sense for a lot of stakeholders that might be around some of those other areas. So anyway, I look forward to supporting the application. I wish the operator well, and hope that you stay engaged with the objectors and the neighborhood, and to the residents. If you have any concerns or issues, please do not hesitate to reach out to the DRMS.
Anything else? So that's for motion. I got everything covered. We have a motion. Would anybody else like to say?
You know, the only thing I would throw out is that clearly they went into the mining business unpermitted, and that caused a problem. And the state, I think, was very lenient. I agree with with that. Jake was very accommodating. And, you know, this is not a small entity. They certainly knew better. So the only way out of this problem is to, in my opinion, is to grant the permit and move forward. And let's hope it all works out for the best, for the neighbors and for the company. That's that.
Do you have a motion?
Yeah, I'll move to amend. Excuse me, with the frog in my throat. Approve the 112C permit application over objection for the farmer's sand file number M-2024-057.
A second.
Second.
Mr. Baker, second. All in favor, say aye.
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 All against? Hearing none. Get the permit. Permit is granted. Thank you.
Thank you.
Thank you.
Mr. Chair, can you give us 5 minutes? Let's break.
Yeah, let's take 5 minutes and then you have a presentation.
Yes,
very
yes.
good. Sorry.
Okay. We're stuck.
Pretty good. Huh? No training for being a judge.
Well, sometimes it's been more complicated.
Yeah.
Say thank you.
Oh, you're welcome. Thank you.
Appreciate your comments.
You bet. Very much, sir. Appreciate it.
Thank you.
Someone cooler anyway.
Someone cooler.
I don't need permission.
All right.
Right through it.
We are reconvened.
We're road with the right of way.
We are moving on to number 6, discussion item. And the department has the presentation for us.
Yes, sir. Not to put light on the seriousness of the last one, but favorite quote from from Monty Python, now to something completely different. So today staff would like to present to the board some information about e-permitting. The division is ready to roll out e-permitting for applications and amendments. And actually, the board will see some of this reflected in our upcoming rulemaking and stuff as part of our modernization and stuff that we're working on. This is a monumental step for us in making this whole application process and stuff more efficient. Kudos go to Eric and also to his predecessor, Susan Bergmeyer and stuff. This has been a long project and stuff that's created a lot of work and efforts and stuff in that, and they've done a fantastic job on it. We have done a few things like technical revisions and stuff, but getting the applications and stuff, forms and stuff in play and stuff is a huge step. Our plan is to do a soft rollout on this on August 4th. We'll be sending out an email and stuff to operators and stuff and consultants, letting them know that this is now available. We're going to keep it in a more or less beta form through at least the 1st of January. That way we can test drive that and see what operators and consultants could do to break it and so we can fix it. You know, if everything goes good, then we'll be pushing that towards the most preferred way for applications and stuff to come to the division moving forward. But if we have other issues and stuff that we need to deal with, then our goal and stuff will be to have it finalized by July 1st of 2026. So to that end, what we would like to do is to present to you the e-permitting form. By act and rule, the board has to approve all forms, but staff wants the board and the public to know we're not changing content, we're just changing format. So with that, we don't feel that, and we want your opinion on that. We hope that you're comfortable with us going ahead and changing the format without having to drag you through all of the weeds and stuff and that of approving each and every one of these forms. So with that in mind, I'm going to turn it over to Eric, and Eric's going to run through the application form and stuff, and that is at a good pace.
Certainly. I will try and take this at a pretty good clip. I know that you guys have had a long day already, so feel free to interject or ask questions or anything you'd like. It's important to realize that this is a little bit more than just a fill in the blank sort of form. The idea behind all this electronic permitting is not only to give the operators a little more clear guidance as they go through this process, but to also make sure that the information that they submit to us gets imported directly into Laserfiche, which is our public web repository or public document repository, and also into the permit system simultaneously. So that is the reason that some of this looks the way it does, is because it is interacting with these other components behind the scenes. So, please, my apologies for some of the appearance of these screenshots. They were taken from the development server, but we wanted to have you guys at least get a pretty good idea of what this is going to look like. This will be the first screen that they come to the minerals new permit form. They have to affirm that they have read and understand the process guidance for this. And they can proceed from there. They will select the permit type. In this instance, we've selected a 112C. It will give them a description of that permit type to kind of help them confirm what it is that they're looking at, and also to let them know what the application fee will be for that permit when they get to the end of this process. There's quite a list of acknowledgements and affirmations you will notice that are part of our existing paperwork that have been recreated here. Anything with a red asterisk in this initial form is a required acknowledgement or a required field.
And they have to check each one of those boxes.
That's correct.
Not just 3 pages down, yeah, I read it all.
Exactly. They have to acknowledge, well,
Yeah.
they have to at least check the boxes. Yeah, I mean, we hope that they read it all, but yeah, they do have to check the boxes.
No, you're totally right. You're right on it. Yeah.
So there's no optional ones anyway, right? It's all mandatory.
Not yet. No, I mean, this, like I said, this is recreating essentially the existing application form and yeah, and pretty much everything in here at this point is required information.
Under the hard copy and stuff, they have to initial it all and then they have to have it notarized. But by going through this process, they're checking it all off and then they're just like in other legal forms and stuff, they're certifying it at the end and stuff for that. So that eliminates that wet signature part of that whole process.
And as we go through here, like I said, this is all information that is currently collected through the existing paper application form. It's just fill in the blanks. So we've got some drop downs for some of these that give them the ballot options. They don't have to try and guess, I guess, at this point what they want to put in those. Commodities, how much, what their proposed acreage will be. For 112s, they have the opportunity to specify a lesser affected area. It will default to the permit acreage unless they specify a lesser affected area for their 112 permit. For 110s, obviously, that's not an option. And that also what lends to some of the complexity of this form is the same form is essentially utilized for all the different permit types. So depending on what permit type they select will determine what fields they get to do here and fill out. So it's a little more complex than it looks on the surface, but we try to keep it simple on the public facing side of things. Got the surface owners and back to your point about having everything here required. This essentially requires all the applicants to fill out a complete application form at the very least. They can't submit to us grossly incomplete applications is our hope with this.
But it looks like they can save it as a draft for a indefinite
Correct.
time.
Yeah. They can keep a copy of this as they go through it. It takes them more than one shot to get through this whole process. They can add additional surface owners if they need to. They can upload additional information, plat maps, anything like that. They feel that that's going to be helpful. And it will total up the acreages for them for their different surface owners. And when they surface acres matches their proposed permit acreage, that box will populate and then they know that they have gotten everything accounted for. And we have spaces here for our various state, local, and federal landowners if needed, along with the acreages that go with those property owners. If they select yes for any of these, a pop-up will appear for them to enter the corresponding information for that entity so that that's also collected as part of this process now.
And if it doesn't add up, does it give you a little warning or does it make you just go crazy like you're trying to figure out?
Yes.
There may be a little bit of initial confusion here. That's why we've included this note that you see here that total surface acreage will populate when the sum of the private plus federal estate, county, municipality acres, and all your proposed acreage for your property owners equals your proposed permit area. So that number will populate.
Can you put that in red ink or something?
We could potentially do that.
Because you know.
We could potentially.
So, but they just put in their acreage. Or do they go get their parcel and their parcel ID from a county or? How does, they just type in the owner and then that owner's acreage.
Correct.
And then, so
it keeps track of
hopefully
that.
they're sharp enough to like know that already, right?
Yeah, that is the hope, yes.
Yeah.
That's part of the process.
What's it, you know?
Pure typos. Pure typos if you got.
Yeah, right. Yeah, no, I get it. I'm just saying, like, if you have 3 owners and they all own 33 acres, you know, like that's not that hard at the end, right?
No, yeah, exactly. Yeah. So, but it does get, like I said, if you're in some of our federal lands and stuff, there's private land and federal lands and stuff and that. And sometimes what this does is this again ties into our permit system as well as Laserfish. And sometimes, we get requests and stuff from across the street and stuff regarding, well, how many, acres of federal land do you, oversee? You know?
Yeah.
And we can go into the permit system if the data is there and click on that and pull up some research and be able to pop out, okay, you know, we have, 16,000 acres or whatever and stuff it is for BLM or this or that. So that's all ties into this whole integrated system.
And hopefully with most construction applications, the subsurface ownership rights correspond to the surface ownership. And if that's the case, they could just check yes here. Everything will duplicate as appropriate in the system and they can move on. If they select no, if there are discrepancies, that they would have to go through that process then again and tell us who the subsurface ownership rights belong to and which acres are associated with that. So again, that's a bit of the reason behind some of the complexity of this, making sure that all that gets correctly accounted for.
Not to be too nerdy, but what's the back end? The SQL Server or how?
This technically is a Laserfish data collection form, Laserfish forms.
Really?
It will bring data into the permit system, which is a SQL database. And it will also bring in the attachments for the exhibits later on directly, and this form directly into Laserfish. So that hopefully will cut down on some of our processing.
Yeah, translating it, yeah.
So as with anything else, we're heavily reliant on our operators to provide us with good information. So. And here we get back to collecting more of the, what do I say? Location. Yeah, more common location information for the site itself, county, section, quarter, township range, all the stuff that's on the existing application form. We also have, oops, got a little cut here. An opportunity for them to give us their entrance location in 3 different types of coordinates. And those will bring up the correct coordinate fields for them when they select whether they want degrees, minutes, seconds, decimal degrees, UTM. In this section here, we've selected degrees, minutes, seconds. So we've got appropriate fields for that information. Method of mining, current and future proposed land uses. We've got a little section here to try and catch potential operations that might be best served with a designated mining operation permit, whether they're using designated chemicals or encountering acid or toxic foreign materials, or may create acid mine drainage. On-site processing. And the standard correspondence information, who's our applicant operator, who's applying, the permitting contact. And if these are the same, they can check the box and it'll duplicate that information. They don't have to enter it 3 separate times unless they are 3 separate individuals or contacts. Same with the inspection contact. They could pick same as the applicant, same as their permitting contact, or they can enter it again if it's a 3rd individual that needs to be contacted. Now, because this was taken off the development server, these first 4 fields will not show up during the actual application process. These are for the development purposes only. But this is the point in the process where they would attach all the different maps and exhibits that are required by rule for the application. And like I said, this is for a 112C, so we've got all the different exhibits and the names of those exhibits. They click upload, they select their PDF, it uploads that PDF, and when that goes into Laserfish, it will be titled appropriately with whatever they submitted to us for that exhibit. And this is a fairly extensive list, as I'm sure you're aware, for all the different 112 required exhibits. And we also have spaces at the bottom for additional notice requirements, maps, geotechnical stability, additional documents they feel they might need to send with this, blasting plans, baseline water monitoring data. They can incorporate those as well. We do have some file size limitations. However, 250 megabytes per attachment and PDF only at this point for uploading attachments. So
And that's one of the things, we have a couple of very large operators, and sometimes when we get even a technical revision, it could be like 3 binders full and that. And so we're going to be working on that to see if there's either a different way and stuff to submit those electronically, or are those the one-offs and stuff that we still have to work on and stuff in that from a manual perspective. So
I think that 250 megabytes per attachment should hopefully capture the vast majority of our applicants' materials. That is just a limitation to the system itself, really, at this point. Now, we've filled out the whole form. We have to click a few more boxes here for affirmations. Get to the bottom of that. And at this point, they would generate a permit number. And this is the permit number that will be assigned to that permit through the application review process. It will also allow the system to tie together this application with the payment that they're going to make. We need both of those pieces to be able to put this puzzle together and make sure everything's processed correctly. They'll get a permit number, they'll put that permit number in here, they'll hit next, and that will take them to the same payment portal essentially that is used to collect annual fees at this point. So hopefully all our operators are familiar with that process already. They make their payment, they take their payment confirmation number, they paste it back in, and then they hit submit. And that will essentially conclude this process once we have that information with the payment and all the required fields and attachments for this form. When we get that, the specialist then will get a notice that there's been a new permit submitted for their county, and they'll go from there through the normal review channel.
Theoretically, this form would eliminate incomplete applications from being submitted. Now, somebody could still upload an attachment for an exhibit that, let's just say it's blank, in which case our specialist would catch that, we'd still call it incomplete. But it's typically not those sort of things that cause an application to be incomplete. It's just forgot to fill out part of the landowner information, or I've got some missing things here. And so this will really cut down on that. I think it's a benefit for staff in terms of efficiency of their review time. It's also helpful for the operators too, because they could have to wait up to 60 days to get that complete application. And so this ensures they're giving us the correct information up front, moving that process along in a little more timely fashion.
So if it was 60 days with all paper, what do you think it will be? Because I guess you still have to do a QC to make sure that it's not, you're adding the wrong file or something like that.
So it wouldn't be an automatic completeness. As Eric noted, we'd still go through our process. And then it would still be under the rule for incompleteness. So they would have up to 60 days to provide us with that additional information and for us to make the determination that it's complete. So that part.
But you would get back to them a lot quicker. You could.
Yes.
More than 60 days.
By rule, we have 10 working days and stuff to get back to the initial application. And stuff. And so sometimes with the paper process and stuff, and that 2 or 3 of those days and stuff are eaten up just in administratively getting there. By doing this, it instantaneously goes into the system, and the senior and the EPS is notified about it. So that right there cuts down on a couple of days and stuff, and that gives people are in the field, doing other things and stuff like that helps and stuff with that process and stuff there. So that really cuts down on that. In that 10 days, if there's issues and stuff, if we look at it initially and say, oh, yeah, you submitted something, but this is a blank piece of paper, we can call that out. And then by rule, they have 60 days to correct that.
And there's just so much pressure, with the NEPA process review and cutting the timelines down. So every couple of days helps, right?
Right, exactly. And like one of the most important aspects is like this goes right into the public file system. So our admin and our specialists aren't having to physically take that and index it and get it into the system and stuff there. It's all done for them. So that's one of the efficiency gains and stuff to get out of that.
And if there's a technical comment or something, they have to redo a file, can they just take out the old one and put in the new one, or is it additive?
The review process and stuff, and that'll still be the same. It's not gonna be, like in coal and stuff, it's a live permit. This is still under our same kind of system and stuff, and that where we'll do an adequacy review, and then they will, have to come back into here and submit those. And that's something we'll have to work on and train both staff and the operators on, is that process, because we don't want them to come back in here and hit a new permit. There's a process and stuff there where they need to, where they can come in and submit, their responses and stuff to our adequacy reviews and stuff moving forward.
There is a form that looks virtually identical to this. It's called modification to an application review, where on this one, essentially everything's required. On that one, they could just make whatever changes they need to make to.
So they wouldn't be able to get back into this file, change it under a modification form?
They should use the modification form. Yeah, for that.
And that'll be part of our education stuff that we're gonna going forward, so. And that again, and stuff that our process, like for adequacy reviews, we send that off and they send us back and stuff, that hard copy. Well, now this, we'll be working really hard on getting everybody to use the system, because then it's instantaneous. It'll reduce some of the admin work and stuff that PSs and stuff now have to do.
And the benefit to not replacing an exhibit during an adequacy review is partly illustrated today in our hearing, is that those, the public can track and say, okay, this is where they started. I can compare that to the changed exhibit and understand what those changes are, as opposed to just seeing a brand new exhibit in the file and then trying to figure out, oh, what changed from the original submissions.
Makes sense. And so if an applicant can't get these big drawings down to a PDF, can they do all of the other stuff online and just bring in their oversized drawings or whatever?
Yeah, we would work with an
For a while.
operator so that they can't get them down to the size and stuff that'll work and stuff there, and then we'll have to work with them on that.
I'm guessing it's more a format, right?
Yes.
Can't get into a PDF.
Yeah, and that would be the more difficult part and stuff there. So.
Slick.
Yeah.
Why don't we start a mining company, people?
Should go to the dredging business. Is that it?
Dig it out.
All right, well, awesome. Yeah, we've asked some, you guys had some great questions and stuff here and stuff. Are there any concerns and stuff, with the division and stuff, continuing the process of changing formatting and stuff at a staff level? We just want to make sure and stuff that everybody's fine with that, and with the understanding and stuff that, it's totally understood that by statute and stuff that we have to bring any content changes and stuff to you. So, but we are working our way through this. Like I said, in our upcoming rulemaking and stuff, you'll see some of this as part of the modernization and stuff, and that for e-permitting and stuff. So with that, we are done today, unless you have any other questions. If something pops up and stuff later on, you think about it, send me an email and stuff, and I'll send it to Eric. So with that,
awesome. Thank you,
we're done.
gentlemen.
Thank you.
I don't see any public, and we don't need an executive. So I did want to say one quick thing. I'm not sure you heard, I told these guys, it's really a pleasure. I'm gonna try and stay as long as I can, but I took a new position as an assistant professor at K-State.
Oh,
So you
where?
probably won't see the Kansas State. Yeah.
State.
Yeah.
All right.
So you're going.
So I'm gonna have an apartment. Yeah, we're not giving up our farm or whatever.
Okay.
So I got a 7-hour drive if I want to see my wife or my kids. Well, my kids aren't there anyway. So yeah, so I won't see you in person probably, but I'm gonna.
I have a niece that's going there.
Yeah.
This fall.
Oh, it's lovely.
Yeah.
I had never been there before, and I
That's a
drove there
good
for the
school.
interview.
Great school.
Yeah.
Where is that? Which town?
Manhattan.
Manhattan.
And that,
Yeah.
Just say Nebraska?
Michael,
Yeah.
Michael, I got a question of you, and I don't want to keep things late, but there's a lot in the news about rare earth mining. Will that impact Colorado? Will we be involved in that?
Well, it tough industry. Certainly, we're watching that closely. We know that there is, a tremendous mineral potential in Colorado, including rare earths. We've not received any applications to date, and we really have not had many extensive conversations with interested applicants on it, but we know folks are looking closely at it.
Well, what are they looking for?
In terms of the specific rare earths,
Yeah,
I
I mean,
There's a,
there's,
there's a couple of different lists. Yeah.
Yeah,
30
there's-
different elements.
Yeah.
there's rare earths, there's critical elements.
You don't think it'll be involved?
Oh, no, I was saying Molly, not one.
It's not, I,
No,
It's not one
it's not, it's not a rare, it's not a rare.
Rare.
And-
except in one place.
And yeah, we're noting, there's multiple lists floating around out there. There's the rare earth list, there's the critical minerals list. There is some overlap on some of those, but we do have distinct elements between those lists, so.
wait, and then what about uranium? I mean,
Yeah.
Yeah,
given some of the national conversations.
uranium probably has a greater potential to see some movement in that area in Colorado. One, given our extensive history in mining uranium on the western slope. We've got a couple new drilling projects that we've approved for prospecting, so there are folks that are moving forward on some of their uranium projects.
On new sites or on historic,
Well, they would be new sites, but within historically
Yeah.
uranium mined areas. Yeah. And so I think we see a greater potential there only because those areas are well understood, well studied. Nevertheless, any new company is going to want to prove up their reserves. But I think that's a lot more solid than where we're at with rare earths currently.
And a lot of the rare earths and stuff dovetail on uranium. So so when someone's doing some prospecting and stuff for that for uranium and stuff, they're also probably looking at the rare earths and stuff that are there. So
There's, the rare earths are one, just the mining of them, but I know there's a lot of interest in looking at other sources. In particular, coal slurry has been identified as a source of rare earths. And so I,
Yeah.
expect in time, we might be having conversations with some of our existing operators about trying to recover rare earths from their operations.
What's really cool though is the uranium plant in Utah, in Landing, Utah, is being permitted to process.
yes,
rare earths, which is pretty cool.
yeah, Energy Fuels and stuff at the White Mesa Mill, they are able to switch out and switch to doing rare earths, and then they can shut down and switch back and go back to uranium and that. So in that, so I think it was 2 years ago and stuff, I was down there, they had a little presentation and stuff, and you were able to tour the site and stuff, and that it was quite interesting. So
And like you pointed out, the mill is kind of the key.
Yeah.
It's always been that chicken and egg thing. So
Yeah.
these mines need places to process those rare earths, and presently we don't have many in the
Yeah.
United States.
that's the one of the big bottlenecks in the entire chain and stuff, and it goes the same thing and stuff with copper and molybdenum and stuff. Copper doesn't have, we can mine the copper, but we can't smelt it. There's not a lot of smelters anymore in the United States and stuff, so that's kind of choking up the copper industry and stuff, and then so.
Okay,
All good?
what about, NEPA functionality?
It's an oxymoron.
Yeah. You can close out the meeting if you want. Go ahead.
Yeah.
Yeah. Typically, it's something that we're not engaged in the NEPA process and stuff, and that's on the federal level.
Right.
And some of the things and stuff that we have talked to our federal partners and stuff, they're working their way through some of the orders and stuff that have come down. Something that's interesting is actually it was a uranium mine, opted and stuff to go through the normal process instead of the accelerated process, because they feel that the accelerated process and stuff is going to be challenged in court and be tied up. Whereas if they just go through the normal process and stuff there, there's a less likelihood and stuff of that becoming going to litigation. So it's up in the air and stuff there. Upstairs, we've had some conversations and stuff in that with EDO as far as those orders and stuff coming out and stuff. In particular for us, the Department of Energy and the BLM and the Forest Service to a certain extent and stuff for the ones and stuff that we work with on active mines, inactive mines and stuff with a lot of their projects and stuff for that, because it's a lot of federal land. They have their own NEPA people and stuff to do that.
Got it. Got it. Doug, thank you very much.
Thank you, Doug.
Thank you.
Wow, been waiting to do that. Thank you all.
You can feel the power.
It's powerful, man, power.
So like in your mind, I can't drag him through,
Huh?
yeah,
What happens? Are we?
but he can close it. He can close it.
Mine's been-
It's,
Awesome. You got through. Oh, my God, yeah. Congratulations.
we- this kind of-
Start calling you professor.
Brings up a good point.
Yeah. Interesting. Yeah, I'm not used to anything different. Except, hey, you.
Very little. You're taking back our.
But you know what? He could have closed it down before, because it's his property.
But thank you very much. Thanks for
Yeah,
that job.
I mean.
Is it that?
Really fine.
No,
Because I know there's a couple of them in Florence,
Thank you.
and they're small, but they take water out of the Arkansas.
See y'all.
Awesome. Thanks.
Nice job.
Thank
So
you.
I didn't want to get into it with that guy, but I wanted to, you know, they let you fit.
Oh, yeah, we're still right here, but I've turned everything off, the system is off. It's just the cameras that are showing right now. Yeah, we're good.
No, I do too.
Nope. We saw you.
Anyway, nice to see you. So are you selling?
Oh, I don't know, but I forgot. It depends on my schedule. Not that far. I don't even know what day of the week it is.
I hope your daughter gets.
Thank you. Yeah, I'll let you know if I need you to bring her some pizza or something.
Yeah, yeah, all her, you got my number.